Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case.
Is that correct?
I didn't ask you to interrupt me from saying that he Anglican or he's
Good morning, welcome to the Court of Public Opinion. I'm the Recovery Addict. A little late this morning, but we had a power outage and everything resets. Like cameras, routers, everything required to be reprogrammed, and it was nuts. So we're going to do a tiny bit of catch up, and we'll be back up with live here in just a moment. I don't know why. Okay, hang on one second. Using the wrong browser. Everything just looks wrong. It's definitely a Monday, so we'll get this squared away. There we go. That's the right one. Pause this here. Perfect. Got it. Then
the apocalypse may be upon us.
Our chat has to be in dark mode, otherwise it will just blind you on the screen. Fixed it. And with a little luck, our buttons still work today. They do. Yes. One thing did not break. Greeners, congratulations. First in chat. Thank you. We're going to be listening live in just a minute. We're like a minute or two behind, but we'll get there because we've got to skip a break. But Greeners, congratulations. The internet's all yours. Don't let the power go out again. If you can monitor that as well, just the national grid, power grid. Just add that to your list of fix-it items. That would be great. Appreciate that. All right. Let's see. We have, I guess we have some birthdays this morning. Happy birthday to those who are celebrating this morning. I'm super excited about that because we get to sing to you, and everyone is going to sing and join me. See, good afternoon from Scotland. I don't want to jinx it, but it's dry and somewhat sunny here for a change. Siri Hunter. Oh, that's hilarious. Yeah, it'll pass. That'll pass. Don't worry. Good morning, y'all. Let's see. Trial started. We're going to be jumping over to it in just a minute.
Happy birthday.
75
you look
in
good.
Arkansas. Ooh, that's not bad. Do you believe you may cover the Megan Boswell trial? They're in jury selection today. I think they're in jury selection. Megan Boswell on that trial, they had to see 1,200. Well, they had to summon 1,200 jurors. That case has so much national exposure, possibly because of the Amber Alert search for her child that went for 2 weeks before they found the poor child. It's a tough one. It's a tough one, like Letitia Stout is tough. Maybe not to the same extent, but that I'm looking at that one. But it would be a rare exception where a child is the victim. But there's a lot of interest in that one, so possibility on that. Let's see, we've got some birthdays here. Thank you very much, Sharon, for that. We have, as I quickly scroll to the birthday song, Robin S58, Barb Russell, Valerie Caveas, I think it's Caveas, Stefan, an Ohio Palm Mom, Greeners, who won the internet today, Niels and Myron. That's a two-verser. I think we could do 3 and 5. Well, we'll go as far as we can, and we'll just do what we can. Everyone stand up with me. Take a deep breath. Shoulders back. Project your voice to the back of the room. Blend your voice with your neighbors. Warm up with me, if you will. La 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 la. Excellent. All right, here we go. Happy birthday to you. Happy birthday to you. Happy Happy birthday, Robin S58. Barb Russell, Valerie Cavea, Stefan in Ohio, Pom Pom. Happy birthday to you. We got all the way through Ohio, Pom Pom. By the way, thanks for the letter, Ohio, Pom Pom. Appreciate that. Greeners, Niels, and Myron coming up next in verse 2 after the interlude. Happy birthday to you. Happy birthday to you. Happy birthday, dear Greeners, Niles, and Myron. Happy birthday to you. Happy birthday to everyone who's celebrating. Robin S58, Barb Russell, Valerie Cavas, Stefan, Ohio Palm, Greeners, Niels, and Myron. There are many special days, but today is your special day, and we're here for it. Thank you very much for letting us sing to you and celebrate a little bit. The privilege, pleasure, the honor is ours. Hopefully we can return that in some small way to you. Make your day a little more specialer. Help yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Andy's Bar Grill, Tammy Dunlap's house, and any other fine establishment that serves pancakes. If they have a problem with that, have them call me. Welcome, one and all. The birthday dance is continuing, so don't stop. Those high kicks, here they go. Oh, yeah. Somebody stretched. It's looking good. Got a free breakfast sandwich at Tim Hortons, says Barb Russell. That is awesome. Free breakfast is just good, wherever you can get it. Okay, I think we've got one more verse and then the drums. Yep, that's definitely it. The toms were our indicator. Air drums for the big finish. Everyone help me here. Here we go. Beautiful. You guys are fantastic. Happy birthday, one and all. We have to jump right into trial because my tech delay caused us to be a few minutes late, and that was my fault. But here we go. We're going to just pick up where we left off and continue. Let's see. We want the counter, right? We're up to 53 on the objections. Is that what it was?
Your plan for this morning? Judge, I'm going to arrest.
Oh.
Yes.
Do we want to handle anything that we normally handle after the state rests?
The state's going to rest.
Yes.
And I'll let you rest.
First thing in the morning, they rest.
In front of the jury. Ms. Thornhill?
And actually, Mr. Hendry will be making the arguments.
Right here in jail right now. Sorry, I was setting my computer up. Sorry. Ready? Your Honor, this time the defense moves for a judgment of acquittal on both counts. I will work with the kidnapping charge first.
No shield now.
The state's charge of kidnapping. First, kidnapping is a specific intent crime, which means that at the time the alleged kidnapping took place, it had to be the intent to kidnap, and typically the intent is to commit something else. So it's charged right now that the intent was to either further the commission of another felony or to harm or terrorize the victim. Now, as far as the evidence that has been presented in this trial about the kidnapping, we have essentially the two neighbor witnesses who presented any testimony whatsoever about the kidnapping. Both witnesses describe Kathy Griffith as angry. They describe her as, stomping around in the yard, throwing things into a car. The first witness described her swinging her arms around a lot, both away from Collin and as she approached Collin, and even up until she was so close that Collin could reach out and touch her. So at that moment, we have the testimony, which seems to align between both witnesses, that Collin grabbed his mother. She exclaimed, according to witness 1, "Let go, you're hurting my hair." Witness 2 did not hear anything. And then, although it has been argued that Collin dragged her into the house. The actual testimony from the witnesses was that the two went into the house. So if we pause it right there, at this point we have what is arguably a misdemeanor battery. We have what could be a defensible touch on Collin's part, that he, in response to his mother swinging his arms in his face, reached out and grabbed her. And whether or not he had the right to do so, either way, it would either be a defensible battery or a misdemeanor battery.
Collin's thirsty this morning.
When examined on cross-examination, neither witness said that they heard Kathy exclaim anything about not wanting to go into the house. They did not see her fighting to not go into the house. They saw her legs moving. They saw her go into the house with Collin. And that moment is what has been alleged and the only evidence that has been shown of a kidnapping. So at that point, Mr. Griffith's specific intent to kidnap has to have been completed. We do not have that in this case, Your Honor. We have not heard any evidence that there was any fight on Kathy's part, any unwillingness to go inside of that house in that moment. We know she didn't want to be touched at that time, that she said that you're hurting me. We don't know if she was upset about him having his hands on her. We do know that he was touching her too hard, essentially, is the evidence that has come forward. And again, that would be a misdemeanor, which would not be sufficient in any case to charge a kidnapping with. So we move on from there. What evidence have we heard in this case that is going to turn this from a misdemeanor battery to a kidnapping? Well, we ultimately have a deceased person in this house. We have, the fact that she is found in the house roughly an hour and 15 minutes after this incident occurred, with the yelling outside and the touch on the upper torso. And we have no evidence of what happened inside the house. We have no evidence that Kathy was not in that house, or was in that house against her will, that she remained in that house against her will, that she was not able to move in that house. The only evidence we have of anything that happened inside that house is the body itself, with the forensic evidence that has come into play from that, and Mr. Griffith's 911 call. Mr. Griffith's 911 call states that there was an extended, prolonged fight, and that they ultimately, there's the accident that she fell on the knife. There is no mention that that fight started outside of the house, that it continued inside of the house, that it continued all the way up until the moment of her death. There is no evidence that she was dragged immediately from the porch into the house and murdered at that time, like the state may offer as an alternative. We have not heard that from any witness. We have not seen that in any evidence that has been presented. So again, the evidence of the kidnapping turns back to the misdemeanor battery, that she was touched, that she exclaimed upon the touch, and that she continued into the house without doing anything else to say that she did not want to go in that house. All of the case law on kidnapping gets into whether or not that the crime itself was completed, whether it was necessary to complete the other crime if there is another crime that's charged. But all of it, every case, includes proof that the victim was held or moved against their will. And we don't have that in this case. So we are not even at the starting point of whether or not you should consider a phase-on test or anything like that that falls under the kidnapping line of cases, because we have not heard a single piece of evidence that says that Miss Griffith did not go inside of that house willingly. So for that reason, we are asking for a judgment of acquittal on the kidnapping charge.
I don't think you need to hear a witness.
As far as the first-degree murder goes, Your Honor,
her injuries all over her body might...
The evidence that has been presented so far of premeditation is that Mr. Griffith had a conversation with his grandfather in which he said that he wants to kill his mother, that he wants to slit her throat, according to the witness. We have the testimony from the officers who stated that he said things like he wanted to kill her. We have the testimony of Mr. Griffith himself in the back of the car where he said that he could kill her. Again, other than Mr. Wallantis' testimony, every one of those officers, every piece of body cam footage, every piece of car footage that we've seen is conditional. That if violence occurs, if she comes at me again, if anything, then premeditation does not override someone's right to self-defense. If it did, then every officer who ever acted with lethal force would be charged with a capital crime. They are trained to respond to situations, and they know how to respond to that situation. That knowledge does not create premeditation. The fact that Mr. Griffith thought about what he would do in a situation where he felt that he was being threatened, and even took it as far as to how he would do it, does not create premeditation. That is not a crime. That can still fall within the realm of self-defense. The only piece of evidence that we have that would go against that is that that he didn't have enough marks on his body. I mean, the state offered physical proof that he had injuries. They have argued that those injuries were insufficient in opening. We have not had any witnesses testify to the extent of Collin's injuries, what could have caused those injuries, what could not have caused those injuries. In order for this to be a first-degree murder, we have to have premeditation, which so far I do not believe the state has proven, and we have to have a waiver of self-defense in some way. If there is just a waiver of self-defense, if this was a fight that got out of control, I apologize, do you have to?
Just my child's school keeps calling, but I'm wondering if there's an emergency.
Yes, Your Honor, I understand.
Judge taking a phone call. Hold up, everybody. His school is calling. So, judge's kid's on the phone in the principal's office. Bring me some chapstick. My lips hurt real bad. I don't know why he's. Hopefully, there's no problem. Might be somebody sick or something. Let's see, Tim. Hello from Denmark. Welcome. Does defense have any witnesses to call? They might. They don't have to. They don't have the burden of proof. But what we do know is that the jury's not here right now, and the defense is putting on a judgment of acquittal before the jury gets there, or putting forth their motion for a judgment of acquittal before the jury gets there, anticipating that the state is going to rest as soon as the jury arrives. So that's the order we're going to do things. We've already been told the state's going to rest, so we're acting as if they have because we're just trying to save time. Because the jury's not present yet. But we're going to zoom ahead because we can. If you give me just 1 minute, let me see if we can. Oh, it's not much longer. Okay. Okay. Now we continue.
Your Honor, I was speaking as to the if this were a fight that got out of control and Mr. Griffith had started that fight, then this is arguably second-degree murder, as would be charged. That this was something that was created inside of the moment, that the decision to kill did not require adequate reflection, and that this would be a second-degree murder. So we have I don't believe that the felony murder should be considered because I don't believe that the kidnapping is sufficient to reach that, and there's been no evidence that the kidnapping was a continuous crime. Again, we have proof of her injuries showing that there was some kind of fight. We have proof of Mr. Griffith's injuries showing that there was some kind of fight. We don't have any proof that Mr. Griffith made a previous decision to kill in this moment, that this was orchestrated in any way by him. In fact, we have the opposite. We have Miss Griffith showing up at that house without permission to do so, being angry as soon as she gets there and never cooling off, according to the witnesses. At the time that she gets into his face, Mr. Griffith acts. From that moment forward, they go inside the house and it's unclear what happened. We have no evidence, we have no forensic evidence that showed what happened inside of that house to show that this was something that was planned, that this was something that was thought out, and that this matched any kind of a decision that Mr. Griffith had made. If anything, it is more likely that this fight escalated once the parties got back inside. This fight escalated. That there was at some point, someone gets a knife, and then Miss Griffith ends up dead. And to me,
tell us more about that.
That is the realm of a second-degree murder. That is a standard fight that goes too far, and that is what the jury should be considering. They have not had any proof, again, that would rise to the level of premeditation. They have not had any proof in this crime that anything else would enhance this crime to a first-degree murder. This is a second-degree murder and a battery that happened beforehand. And it is arguably self-defense on either issue, but again, I will concede that by raising self-defense, we have created a circumstance where the jury has to make a finding of fact. So I'm not arguing that this entire incident can't be considered by them. I'm just arguing that it should not be a kidnapping and it should not be under the felony murder statute, and it should only be a second-degree murder.
Your Honor, as it pertains to the kidnapping, from two independent witnesses we saw and we heard that the defendant grabbed Kathy by the hair. He did that forcefully. And what did he do? He dragged her / pulled her in against her will as she was protesting and yelling loud enough so that one of the witnesses could specifically hear from inside, looking out the window, "Stop, Collin, you're hurting me." At which point the defendant dragged her / pulled her into the house, which was clearly forcibly, which was clearly against her will. And then once he had her inside, of course, he confined and/or abducted her from outside into inside and/or imprisoned her. The last place that she would want to be would be inside after being yanked inside by the hair by her son, who has told multiple people, obviously, his intention to kill her, when he's furious, when she had just sent him the text message regarding the other person that he murdered by shooting that person in the chest and then in the head, and when she threatened to come forward and tell the officials in Oklahoma and elsewhere about the defendant confessing that it in fact was a murder, that it was not self-defense, and that he had planned it, the defendant's anger level was through the roof. So once he gets her inside, he has no prying eyes, he has no witnesses, and he can inflict anything and everything he wants to on his mom. So once she gets yanked from outside to inside, and mind you, he had her by the hair, which there's no way she could get loose from that. So as he yanks her inside, once that door closes, that was clearly the beginning of the end for her. Now he's all alone with her, with no witnesses and nobody that could help her. And his intent was to inflict bodily harm upon his mom, or to terrorize her, and or to commit or facilitate the commission of the murder. Judge, once the defendant gets her inside, there's not going to be an hour and 15 minutes of these two people talking and having a rational conversation. It was an absolute powder keg that went off immediately. So the defendant, as we come now to the first-degree murder, you can see the pathway by which the defendant pulled her by her hair, dominated her physically. He's 6'2", outweighs her by, who knows, maybe 30 pounds or so. He's bigger, he's stronger, he's younger. He had to go to the butcher block, take out the knife of his choosing, continuing on with the premeditation, and then stab her, not just any place, not just cut her, but stab her in one of the most vulnerable parts in the human body, which was right in the neck. And as we heard from Robert Willantis, the defendant accomplished exactly what he wanted to do for so long, which was to stab her / slit her throat, watch her bleed, and watch the life drain from her, which is exactly what he was able to accomplish with premeditation. So, Judge, I would rely upon the facts of the evidence and the whole record, and ask that you deny the defense's motion and allow the jury to consider both the kidnapping charge as well as the 1st-degree murder charge as we go forward, Your Honor.
Your Honor, as to some of the arguments just made, first off, there's been no evidence of anger in the moment on the part of Mr. Griffith. We have the evidence from the neighbor that he was calm, that Kathy was irate, that she was flailing around, and that he reached out, but that his demeanor did not rise. Like, he didn't start, there was no evidence of rage or anything like that. So I know the state keeps using those words. That's an argument on their part, but that is not the fact that has been shown in this case. As far as the decision to choose a knife, again, that's not a fact in evidence. As far as the decision to dominate her physically, well, we have evidence of bruising. So I guess I would concede that there was a physical altercation, and it looks like Miss Griffith bore the worst of that. But I don't know that dominate physically is something that has been testified to in any way. Again, it's being argued by the state attorney. The size of Mr. Griffith that keeps coming in from the state's words, that he's 6'2", that he's some weight, we don't have any fact on Mr. Griffith's size. I mean, the jury has observations. They can see me standing next to him, and they can tell that he's much smaller than me, and I'll tell you, I'm not 6'2". So I don't think that comes into play in a decision to, decide whether or not this was a premeditated murder. And as far as the kidnapping, again, the only evidence we have of Kathy's intent is when she shows up mad, when she's throwing things in his car, we have her intent. Yeah, and she had already gone into that house. I mean, she goes in, she comes out with stuff. That stuff was not sitting inside. So we have her not wanting to be pulled by the hair, but again, we don't have any proof that she was pulled by the hair. We have the autopsy of her body. We do not have a single shred of evidence that she was harmed in any way by a grasp to her hair. There's no bruising of her scalp. There's nothing like that has been shown. So she said, "You're hurting me," loudly enough to be heard. That's a battery. She did not say, "No, don't take me in there. I don't want to go in there. Stop." She was not dragged. I asked the witnesses specifically if her feet were going up the stairs, and they said yes, that she was moving her own legs, that she went into that house. So I understand the state's argument that they are making, but it is argument. They are not using the facts that have been shown. And the fact is that this is not a kidnapping. This is a misdemeanor battery and then a fight that happened inside, and that fight led to a death.
Angie, congratulations on 25 months. Thank you so much.
Taking the evidence in the light most favorable to the state, as I must, hearing on a motion for judgment of acquittal, I do find that the state has made a prima facie case as to each element of each offense, and the motion is denied. Is there anything else we need to discuss before we bring the jury in?
Judge, when do you usually do a jury instruction conference?
After everyone rests.
Okay.
Was there something in particular you wanted to address now?
No.
Are we ready for the jury?
I believe so.
All right, we've got just a brief pause here. We're going to cut away from what we skip. Skippity-doo-dah. Waiting for the jury. The jury's coming in. Here we go. We're getting caught up. We were a couple minutes behind this morning, so. Somebody asked why were the cameras not working? All the cameras in the house. She was killed, or she died, at her mom's house, not at her own house. Her mom didn't have the cameras.
Good morning, ladies and gentlemen. I hope that you had a restful weekend. And thank you again for your service in this case. Mr. Levine?
Your Honor, the state rests.
The state having rested its case, what says the defense?
The defense calls Susan Detman to the stand.
Eating my morning oatmeal.
This way, man.
Sorry.
Step right here, raise your right hand, be sworn by the clerk.
The attorneys are present, so the testimony you give in this case will be the truth, the whole truth, and nothing but the truth. I do.
Ms. Detman, will you please introduce yourself to the jury and spell both your first and last name?
Susan Detman. Susan is S-U-S-A-N, and Detman is D-E-T-H-M-A-N.
Ms. Detman, how are you related to Collin Griffith?
I'm his maternal grandmother.
So your daughter was Kathy Griffin?
Yes, ma'am.
Griffith, sorry.
Yes, ma'am.
Okay. So give the jury a little bit of an idea of who the other members of your family are. Who was Kathy's father?
Robert Willantis.
Were you married at some point to Robert Willantis?
Yes, we were married for 19 years.
When did you divorce?
We divorced in 1998.
After you divorced Robert Willantis, did you get remarried?
Yes, I did.
Who did you get remarried to?
Inaki Markovich.
Okay. And you might need to spell that last name for the court report.
M-A-R-K-E-V-I-T-C-H.
Ms. Detman, who are your children from your marriage to Robert Willantis?
John Paul Willantis, Kathy Willantis Griffith, and Christy Willantis Rooney.
Did you list them in ascending order of age, youngest to oldest?
The youngest to oldest.
Yeah. Okay. Do you have another child?
Yes, I do.
Who is that?
Kevin Markovich.
And that's from your marriage to Mr. Markovich?
Yes.
Now, Kathy, obviously Collin was Kathy's son. Did she have any other children?
Yes, she had an older son. He's still alive, Christopher Ray Griffith.
How old is he?
He is 24.
I want to ask you a few questions about Robert Willantis, your ex-husband. When you divorced in 1998, who got custody of your 3 children with him?
I did.
And since 1998, has Robert Willantis been a big part of your life?
No, except for the custody battles we went through.
What about, are you aware of his relationship with any of the 3 children that you had with him?
He didn't have a relationship. Once he was not granted custody of John Paul. He didn't want Kathy, considered Kathy to be damaged goods. He only sued for John Paul.
Okay, but what was his relationship like with his children after the divorce?
He didn't have a relationship at all until Kathy divorced and she reached out to her dad.
When did Kathy divorce her husband and the father of Collin and Christopher?
2019, if I remember correctly. It was like December of 2019 when they filed. And I think it took a couple months for the divorce to actually take place.
Okay. Now, we saw pictures of Robert Willantis on a trip with Kathy.
Yes.
Tell the jury about that trip, what you know about it.
So Kathy wanted to meet the biological Robert's mother, the biological grandmother, because Kathy had many medical problems. So she asked me, she said, Dad said he'll take me to California to meet his mom. They lived in Anaheim. The mom lived in Anaheim, California, but you'll have to pay for it. And I said, okay. I said, just please try not to do anything too expensive. And I'll see what points I can use for the hotels. And fly over there. You guys don't need to rent a car. We can use your dad's car if it can make it to California. If not, then we'll get a rental car.
So, Ms. Detman, did you in fact pay for Kathy to go on this trip with Robert Willantis?
Yes. I paid for all the food, all the hotels, Disneyland, all of that.
And when was that trip?
That was before she got Collin back.
So before 2023?
Yes.
After 2019, though?
And after COVID was over with.
Okay.
So I believe it was 2022.
Are you aware of any other trips like that Robert took with his other two children?
No. He didn't really have communication with them.
All right. So I want to ask about Kathy's funeral or celebration of life. Did the family hold such a thing for Kathy?
Yes. We had a celebration of life right here at the funeral home in Lakeland.
Was she actually buried or was she cremated?
No, she was cremated. She had conveyed to me as well as to her sister and brothers that she never wanted to be put in the ground. She wanted to be cremated and later taken back to the ocean in Key Largo and her ashes be put at the Jesus statue that we have under the water in Key Largo.
Has that been done?
No, we're going to do that this summer.
Where are Kathy's ashes right now?
Right now they're at Christy's house.
Was Robert Willantis invited to the celebration of life?
No, he was not.
Why not?
Robert tends to be very disruptive. He has difficulty with truthful manners, and we just did not want to have more lies and disruption. The final time that we could say goodbye to Kathy.
But she talks with her eyes closed.
I'm going to ask you some questions now that may also be difficult. In the last roughly 2 months before Kathy died, what personal medical things were you going through?
So in the last part of June, I was diagnosed with stage 3 colon cancer. I had to have part of my colon removed and an ostomy put in place.
After you were diagnosed and had your surgery, did you have a fight with Kathy over Robert Willantis?
Yes, I did. Kathy was very adamant that she wanted Robert to take care of me, that I needed to pay for his flight from New Mexico to Lakeland, get a hotel for him for 2 weeks, and get some sort of a car, and even pay for his food. And I told Kathy, I said, that's ridiculous. He hates me. I don't want to be hurt by him. Plus, he has lost his nursing license. I want a real nurse that has...
Okay, hold on.
I'm going to just object to all this collateral accusations.
Ms. Detman, as a result of you not wanting to follow Kathy's wishes as far as Robert Willantis coming here and taking care of you, did that cause a break in communication between you and Kathy?
Yes, she refused to talk to me. She blocked my phone. She told me if I came over to the house, she would have me arrested for trespassing. She said, you can contact Collin, but you can't contact me.
And that, okay, I'll move on from this. Mr. Willantis on the stand mentioned that Kathy got Collin a second phone and that must have been what Collin used to talk with Mr. Willantis on the phone every week or every other week. Tell the jury what you know about a second phone.
The second phone, I purchased a second phone when Collin came to live with me in the January-February time period, the first time she threw him out, and I couldn't leave a kid in the double wide by himself without a phone. Plus, since I didn't
Well, wait, hold on. Why didn't Collin have a phone with him when he went to live with you in January of 2024?
Because Collin and I were at the Mexican restaurant in Port Charlotte. Kathy and Collin and I were supposed to go. When I got there, Kathy said, no, I don't want to go. And I said, come on, at least have some nachos or something. No, I don't want to go. And I said, can I take Collin with me? Sure. So while we were at the Mexican restaurant, she called me and she said, don't bring Collin back. I never want to see you or Collin again.
And the phone that Collin had at that point, where was it?
It was at Kathy's house.
Okay, so you brought Collin to
the double wide in Arbondale, and I didn't even have internet because, of course, I wasn't there all the time. So if I needed to, I'd hotspot my computer. I didn't want an extra expense for internet or cable or any of that. And so I realized I couldn't leave Collin here without a phone. So I told him, I said, we're going to have to go to AT&T and get a phone for you. And I even got a 786 area code because that's the area code that I have in the keys.
And that second phone, did Collin have possession of it from January of 2024 all the way up until September of 2024?
No. He only had possession of it for that small amount of time from when he came to, which would have been, it was either the end of January or the beginning of February. He had possession of it there. And then when he left, he took it, and I immediately got it by that weekend.
Okay, I'm actually going to show you what's been marked as defense exhibit number 16 and see if you recognize it.
She's not reading because she's going to need her glasses to read this or look at it. It's definitely a different image of what I thought she might be like compared to the phone calls, recorded phone calls we heard.
See if you recognize those messages from January of 2020.
This is the first witness the defense called. This is Collin's grandma,
Well, do you
Kathy's mom.
recognize those?
According to this,
Okay, don't read it. Do you recognize those messages
No.
between you and Kathy?
No.
Okay.
She doesn't recognize the messages?
Do you remember there being a period in January of 2024 where Kathy, where Collin was with you for several weeks and Kathy didn't remember that he had gone with you?
Yes.
And do you know what was going on with Kathy at that time?
She was suicidal, taking pills. She just didn't want to have her life. She was drinking excessively. She drank Everclear as her alcohol of choice.
Okay, Ms. Detman, just answer the questions, okay?
Yes.
Don't volunteer the additional information, even though the state doesn't
You mentioned
object.
that she was suicidal in January. I'm going to show you what's been marked as Defense Exhibit 15.
matter of those texts.
Yes.
Judge would like to admit defense exhibit number 15 into evidence.
Objection?
No objection, Judge.
And received.
Ms. Detman, defense exhibit 16, dated February 5th of 2024, and the blue text at the top was Kathy's number 941-258-0963.
Yes.
And were you the number below that?
Yes, ma'am.
Okay. And you mentioned a 786 number, but you had two phones, correct?
Yes.
Why did you have two phones?
I used one for work and one for personal.
So the blue message on top talks about Kathy just having been released from the ER for an accidental overdose. Was that one of the times that she had had a suicide attempt?
Yes.
So the phone that you bought for Collin in either January or February of 2024, and I'm sorry if you already answered this, but he didn't keep that after the brief period that he lived with you then, did he?
He went home with it and I had it back on the weekend.
Okay, so shortly after he went back home to Kathy.
Yes.
So Kathy, it sounds like off and on had estrangement from various family members.
Yes.
You mentioned that you and she didn't speak for quite some time after cancer diagnosis. Had she cut other members of the family off at other times in her life?
Her and John Paul were not speaking.
Do you know why?
Yes. She got mad at his wife because the house wasn't clean to her standard, and she said, I'm going to call DHS, which in our state is Child Protective Services, that Isabella was not taken care of, that she was in danger, something. I know DHS ended coming up to John Wolantis' house. Of course, the investigation proved that there wasn't a problem, and John just said, I will never have anything to do with her again. She crossed the line.
Any other family estrangements from Kathy besides you and her brother John?
So Kevin and Kathy were supposed to go to Washington, D.C. together.
Kevin is your son with
Yes, and Kevin and Kathy were pretty close. They were supposed to go to Washington, D.C. together because Kevin was in officer basic training in Virginia for the Florida National Guard. He just graduated from college, and he had time off during the 4th of July. And Kathy said, it'd be great if Collin and I could meet up with John Paul in Washington, D.C.
Do you mean Kevin or?
Kevin, I'm sorry, Kevin would meet up. I was supposed to go because, of course, my cancer, I couldn't.
Miss Volantis, I'm sorry. I know you're nervous, but the estrangement,
Yes.
how that
So what
occurred.
happened is Kathy contacted Kevin and said, unless you help me get your father arrested, meaning Inaki Markovich, I don't want you coming to Washington, D.C. with me.
Do you know what Kathy was referring to as far as helping her get your husband arrested?
Yes, they had an altercation, in our farm in Arcadia during COVID, so it was during 2020, around Easter time. It was before Easter. She threatened him with a baseball bat, and she said she was going to get her gun and shoot him. And my husband brought a shotgun out and said, I have a shotgun here. We're not going to be doing this. And later, she said that he used the shotgun, fired the shotgun. And I said, it was a double wide. I think I would know if a shotgun had been fired in the ceiling in a double wide.
Okay. So after that interaction between Kathy and Kevin, were they estranged from each other for a while? But it sounds like she would kind of change her mind about who she was close with or wanted to have communication with. Is that?
Yes, because she called Kevin the next day and said, I'm sorry, come on to Washington, D.C. with us. And Kevin said, I already told my cadre, my leave's been canceled.
Okay. Are you aware of threats that Kathy had made to commit suicide?
Yes.
How many are you aware of, if you know?
I'm aware of 5.
Okay.
No, 6.
I'm going to show you what's been marked as Defense Exhibit 14.
See if you recognize
Interested to see what cross is like on this one.
Yes, I do.
I'd like to admit Defense Exhibit 14 into evidence, please.
Objection.
No objection, Judge.
Be received.
Really feeling close to this defense
What
attorney.
is this exhibit?
Super close.
I wasn't sure if Kathy showed that to me. I wasn't sure if it was blood or a magic marker because I didn't see it physically. She said that it had something to do with a song she was listening to. And she was upset because of the divorce.
And you can't quite see it now, but did you see a video of, so you can see the triangle for play. Had you seen the actual video of this?
Yes.
In it, can you see what's written on the left side of Kathy's arm? I mean, you can't see it right now, but do you remember what it said?
I don't remember what it said because it was just so horrific that that she was doing this to herself.
I'm coming up here, so don't forget to give it to the clerk.
Have you actually called law enforcement on occasion when Kathy made suicidal statements to you?
Yes.
All right, so you said you know of about 6 threats. What about actual attempts by Kathy to kill herself? Or was that the 6 and I misunderstood?
Those were the 6 attempts.
Okay. Can you describe some of those for the jury?
Yes. So the first one was while she was still married, and she was very upset, and she had
Thanks, Dan. I'm getting it
overdosed
right now.
on her
I've got it.
trazodone. And she told me, I was in Key Largo, and she lived in Key Largo at the time. And I said, I'm going to have to take you in right now to emergency room. You're going to die. And she said, no, I'm not going in.
Ms. Detman, it's okay. You don't have to give all of those details. That's all right. I understand. So that was one attempt. What about other attempts that you were aware of?
So the second attempt was when she was in Port Charlotte. I had to go over the fence and open the sliding glass door, and she was in her bed, all dressed in black, and with a revolver in her hand.
Oh my goodness. Red pen.
And had she done anything with any medications that time?
She had overdosed on the oxycodone.
Did she end up going to the hospital that time?
Yes.
Any other attempts that you remember?
Yes. There was another attempt with oxycodone again about 4 months later. Then there was an attempt with medication and Everclear. The second attempt, she went back to the emergency room and was admitted, Baker acted. The third time, when I called Port Charlotte Police,
Lee,
they got there
congratulations.
and
Thank you
said,
so much.
she appears fine to me. If she wants to drink in her own house, that there's nothing we can do. And then the
Bug Duggar, thank you.
most recent time was just in August of this year, August 21st. She called me and said she had overdosed on metoprolol, her heart and blood pressure medication, because the other ones didn't work. So she said, I did that, and I said, have Collin take you to the ER. No, I don't want to go. Have Collin take you. Finally, I talked Collin into taking her to the emergency room.
So, to your knowledge, Collin was home when she overdosed and actually had to drive her to the emergency room in August of 2024.
Yes.
Thank you, Kells Bells. This is a.
You
this
mentioned
is a
that
sad
Kathy
story.
had been Baker acted. Was that more than one time?
Yes.
Tisha, thank you so much. Congrats on
The jury
14
has
months.
heard a lot about some things that Kathy claimed that were maybe not true. How would you describe Kathy's reliability or her reputation for truthfulness?
Objection, Your Honor.
Judge, can we go sidebar?
Hang on, this has been ruled on a couple times. This exact objection, right? This witness, her demeanor when answering a question, and it might be that, as a result of some of the cancer treatment she went through, when she answers the question, she closes her eyes and focuses and answers. She did not bring any notes up to the table. We watched. I went back and looked. She didn't have anything in her hands. There's no paper on the desk. It's the same position you'd be in if you're reading, but she is not reading. As a matter of fact, she's had to put her glasses on to see a couple things. But the what we are all seeing through this testimony is this family through many generations has been broken in many ways. Kim R. Oh my goodness, just finished 25 hours of OT, sharing some of my hard work in with you for all of your hard work. Kim, putting in the long hours. Thank you so much. 25 hours of overtime. That's incredible. Get some rest, Kim. Get some rest. That is super generous. Thank you. Thank you. Yeah, it looks, if we didn't know the information, if we didn't have the video going up when she took the stand and knowing her cancer treatment, which can make it difficult to focus afterwards or follow thoughts through, it makes sense that she's focusing intently on the answers, and I think she's doing a great job. Now, I realize that she is sharing a lot of things that are negative about the victim. What's happening here is defense is trying to say that this was a self-defense case, and they're trying to show the the behavior of the mom that would make it congruent with the mom attacking Collin, Kathy attacking Collin. And so they're literally putting in all the bad stuff they can about her to show that she, had thoughts of self-harm, that she took action on those thoughts, that she, had major changes in mental state, and all that. And I think it's working. I'm not sure if it's enough that I don't think it'll overcome the evidence in this case. I don't know. The jury can do lots of things. Regina Crawford, getting closer to 24 months, but it feels like the month of January is slowly creeping. Thanks for all you do. Thank you very much, Regina. 18 months. You are definitely getting closer. It's building quickly. Drama Llama wants to know, what do you do? 24 hours of OT. You don't have to share if you don't want, but just read that. I saw it coming. Yeah. For those that are curious, I am capturing the ice fishing trial sentencing is going on right now. We've got that right here, as a matter of fact. I'm watching on my little screen on my desk. So we'll have that, and we'll be able to get the full circle on that case as we watch that. Remember the ice fishing trial? That's the guy that had the airboat that came around and rowed the boat around the guys that were ice fishing on the little inlet, and caused the ice to break up, and somebody nearly drowned. Did he nearly drown, or did he drown? No, I can't remember. I think it was a nearly drowned. Mel Poi, wow, that year went fast. Thanks for the best audio on YouTube. Thank you, Mel. Thank you. I appreciate that. It was breaking the ice, Tim. It's a crazy trial. That trial had body camera footage that will make a sailor blush. It was the most eye-opening. Yeah, we're not going to play that again. But the defendant went off on camera about the real reason why these two families who lived sort of near each other hated each other, and it had to do with discretion and not having any relationships that cross boundaries between married people and other married people's wives. It was an almost drowned. I think that makes sense. You missed the ice fishing trial. That was a crazy one. Infidelity, yes, a little bit of that. Let's see, nearly but got injured. That makes sense. He had some health issues afterwards. This sidebar has taken a long time. The decision the judge is making, the objection was they want to get into Kathy's reputation for truthfulness. And defense is making an argument to say this is why we should be able to go into an area that normally would not be allowed to go into. Tony, member for 3 months, says best 90 days ever. Tony, thank you so much. Appreciate you, my friend. Thank you for being here. And that courthouse, you're already on your third courthouse color. It changes. Well, it's going to change slower going forward, but it looks awesome. The name of the ice fishing, was it Tanner? Wasn't it Tanner was the name of the ice fishing defendant? Tanner Carr or something? I don't remember off the top of my head. It's going on now, and I've got it on my little screen. Yeah, Tanner. Green-Eyed Cat also just had a color change on the courthouse. Member for 6 months. Member of the jury. Says, I have a new color. Thanks for everything, Scott, mods, and chat. Love you guys. I forgot to count this objection. Let me go ahead and add that to the list. We are now up to 55. If I can get my mouse over there. There we go. So 55 objections. Are we taking a break? Are we sending the jury out for a proffer? This is wild. Okay, we're going to, if we don't come back right now, we're going to skip forward.
Ms. Detman, I'm going to go through some individual things and ask you about them, okay? First, I'm going to approach with defense exhibit number 17 as it's been marked.
Amanda H., 21 months. Wouldn't be the same without you here, Amanda. Thank you very much. Congratulations.
Just read it and see if you recognize it as being a text from Kathy to you.
Whoa. Take the mic from the coffer. That was loud. Holly Mack, congratulations on 19 months.
Do you recognize?
Yes, I do.
I'd ask that defense exhibit number 17 be admitted into evidence.
Any objection?
No objection, Judge.
It is received.
Miss Violet, thank you. Lois upgraded to the jury as well. Thank you, Lois. Lois has been a long-time supporter of the channel. Appreciate it. Thank you very much.
In this text from June 27th of 2024, Kathy says that she was here and pressing charges going to 77 Hewlett Drive. That's your address, correct?
That was the address in Auburndale.
Okay. To check on you and to pick up Inaki for charges of attempted murder and assault against you. Meaning she's claiming that Inaki actually tried to murder you, correct?
Yes.
Is that true?
No, he's never tried to murder me.
Thank you, Natalie. Thank you so much. 15 months.
So that's something that Kathy threatened and claimed that just simply wasn't true, right?
Exactly. Yes. Yes.
Has she done that on other occasions, make things up?
Yes. Yes. She made up that I was diagnosed with Lynch disease, which is it's an auto-recessive disorder where people have to have, they're more prone to cancer. So she said that her insurance company was forcing her to have a hysterectomy because of that. She also told Christy, and Christy was so distraught.
Okay, Ms. Detman, I'm sorry. No, it's okay. I understand.
Ricky, thank you for 10.
So she made up that you had a disease that you do not in fact have.
No, I verified with my oncologist that I didn't have.
She also made up that John Paul Volantis had been neglecting his child, right?
Yes.
Has she ever made anything up about Robert Volantis?
Yes.
What did she make up about Robert Volantis?
When she was younger, she said that Robert raped her.
And how do you know that that's not true?
It went to court,
okay.
So I don't know. I only...
Did she ever tell you that she had made it up?
Oh, yes. Later, as an adult, she told me she had made that up.
Did she say why she made it up?
Yes, because she was mad at the situation between Robert and I.
Okay. Has she ever made anything up about her being responsible for everybody else's successes in the family?
Yes. She went as far to say that no one in the family would have any of their degrees, and that she, in fact, the only reason that I got my doctorate was because of her.
Okay. And did she actually make a threat to you regarding this belief she had?
She said she was going to, when she was mad at me one time, she said she was going to contact the university where I work at, and I said, go right ahead. No, I had to.
What did she tell you she was going to
She said
say
she
to
was
them?
going to call the university, my dean, and tell him that she did all of my coursework and that I didn't do anything and that I was a phony.
Whoa.
Did she make up at any time that you're aware of that Collin was failing school?
Yes, she said that he had been failing school, and that when he was staying at my house, that it was my fault because I wasn't observing him on the computer to make sure he was doing his work.
Was Collin ever failing to your knowledge?
No.
When did Collin graduate from high school?
He graduated last June.
Was that actually ahead of schedule?
Yes, that was a year ahead of schedule.
And did he, in addition to graduating early, did he ever, did he get college credit?
Yes,
at the same time?
He was dually enrolled in college.
You mentioned earlier that you had paid for some trips, the trip for Kathy to go visit Robert Willantis and meet his mother.
Mm-hmm.
Did you pay for other trips for Kathy?
Yes, the cruises that they went on, I paid for.
And the other trips that the jury has seen pictures of Kathy and Collin, who paid for all of those trips?
I did.
Did you also have, you mentioned points and using points for things.
That's our DVC, our Disney Vacation Club, as well as I have points through Hilton Honors.
Have you ever witnessed Kathy not being able to control her temper?
Yes.
Can you describe some of those times?
She went at...
Your Honor, if we may approach for a moment. The headset that Mr. Griffith is using is on mute somehow. I can't figure out how to unmute it. It doesn't appear to have any buttons on it at all, but I may not just know how it works.
We're certain that it's plugged in.
It indicates that it's on mute. It has like a little, that's the one I've been using.
Tech bailiff has fixed it. Okay. Looks like we've got everything back in order. Let me see if we can switch back to a different camera here. There we go. I like this picture better. It was awesome to see Vice Baby, his first live stream on YouTube. He's the son of Jeff from Legal Vices. He did a gaming stream, I think on Saturday, American Trucking Simulator, and did a Q&A Saturday morning. And it's rare to see this, but it's rare to see somebody's first YouTube live stream have more than 1,000 subscribers before they ever go live. But the big community showed up to welcome him to YouTube and to express just their thanks for the relationship they had with Jeff, with Legal Vices, before he passed. So that was really neat to see. It's awesome. All right, Emily Aaron says whole family was messed up. The kid never stood a chance of being normal, in my opinion. No excuse, though. I agree, not an excuse, but how many cries for help have we seen? Well, I'm going to skip ahead if we can. Give me just a second. I know we can. I just need the remote. Okay, give me just 1 second. There we go. All right.
Discuss the matter with the lawyers. We'll do this.
All rise, please.
Okay, so we're going to take a quick break to discuss the matter with the lawyers. Jury's leaving right now. Hopefully we get to hear that as well. Ricky, my friend, thanks for gifting the 10 memberships. That is awesome. 10 wonderful people now in green. Thanks to you. We're just a couple minutes behind, but we're catching up. All right, what's the issue with the lawyers? What do we get to hear? I'm going to count that last one as an approach. Maybe approach as an objection. I think that's what led to this. So, Judge looks to be reviewing the transcript, like the raw copy. Jury's now gone. Defense has some text messages in front of him. Judge is reviewing the transcript. This might be argument about a objection. And it also could be a proffer. Is Connor in here? I didn't see him. Did I miss? I'd be surprised if you were on my channel. I'm not. But you were right. He does have a voice like butter, made for reading. He's really good that way. Cindy Lou. 20 months. Wow, time flies when you're having fun. It sure does. Yeah, I'm not sure what we're reviewing here. Hopefully the judge will let us in on a little secret. Babs Austin, member for 17 months. So many membership marks being hit today.
There's two separate things here. Specific instances and reputation. Specific instances need to be known to the defendant as far as I read the instructions. As for reputation, there are two instructions, one when the reputation is known and one when it's not, but it's offered to prove that the alleged victim acted in conformity with that reputation, which is, I need you to talk me through how you're doing that. Or are you not using that?
No, I think it is relevant because the defense is that Kathy grabbed the knife in the house in Auburndale, and that fits with past instances where she pulled a gun on Collin, where she attacked Inaki with a baseball bat and said she was going to get a gun, where...
Josh, thank you. Welcome to the attorney.
Pinned her then husband against the house with a car, that she stabbed her husband and burned him, and those were in front of Collin, and she has independent knowledge of those too. So those are the specific instances.
Judge, I have nothing further to elaborate on besides my objection in the hallway, and I object to anything that will be contrary to what Your Honor just read in the jury instructions, Your Honor. It might be it might be a question by question journey to see what, if anything, is admissible or relevant based upon the application of the question asked by Ms. Thornhill, the jury instruction differentiating between, as Your Honor pointed out, the reputation or things that the defendant has to have been present for, have personal knowledge of, and Ms. Detman, depending on how narrow, or maybe I should say how wide her answers are going to be.
Yeah, there's serious risk of
As
her
far
saying
as
the
her
dad got
reputation,
shot.
it's my understanding that her reputation within the family was for being dangerous and violent, and people were scared of what she might do at any given moment.
Brittany B, welcome.
So I was going to ask about both.
While I understand the community, for purposes of this type of reputation evidence, may be narrower, you're still going to need to lay that predicate.
Sure.
This is a family of estrangement, after all, it seems. So
Because of her violence.
Well,
yeah.
But I don't know who's estranged from who else. So,
well,
she needs to understand and know that family and community.
Okay.
So.
And even if somebody's not still a part of that community on this particular day, I mean, they don't.
I'm not suggesting it has to be at some particular instant in time, but I haven't heard a lot about her closeness with others who may share that in that reputation or have knowledge of that reputation.
Okay. I will do my best.
And we'll just take it question by question, as Mr. Levine suggests.
Okay.
Do you want to go ahead and just take our mid-morning recess?
That's what I was going to ask, if I could run the question.
Mr. Levine?
Yeah, that's fine, Judge.
All right, we'll take 10 minutes.
Okay, while they take a break, we're going to catch up. They get a 10-minute break. Hold on. Oh, we're almost caught up. Hang on one second. I think we're still 2 minutes behind, but we're almost there. Now you thought you'd get a shower, but no. We're skipping all the breaks when we caught up. There's our defendant. He's back. He hasn't been hiding today.
We're back on the record. Defendant is present.
Spoke too soon. There he goes.
Present. Are we ready for the jury?
Yes, sir.
All right.
Sarah Sherwood, member for 12 months, says, I'm conflicted. Normally I'd say not guilty for self-defense, but the fact that he did the same thing before to his dad is nagging at me. Now, the jury's not allowed to know that. So the jury, we know more than the jury, obviously, as that's usually the case. But we know things that are not permissible to consider in this case by the jury. So the jury may make a different decision than we do. The judge has ruled that the fact that he shot and killed his dad previously cannot come in. They can tell the jury, and they have, that he shot and killed someone in Oklahoma before moving to live with his mom. So that we've danced around that so closely that the jury can see what fill in the blank based on all the other letters have been shared except for DAD. They know. The jury knows, but not officially. Pan away as he shares a note with his attorney. Jamie, member for 17 months. Love this community. This is a very difficult trial. It is. The details of the situation are heartbreaking.
All rise, please.
The chance that the dad gets mentioned by this particular witness, by his grandma, are very high. Very high. The attorney's got to keep tight reins on her, and she's doing a good job.
Please be seated.
Ms. Detman, I'm going to ask you about some specific instances and may ask you to describe a little bit about them. So starting with, are you aware of Kathy having pinned her then husband to the wall of the house with her running car?
Yes, ma'am, I know.
Okay. And were you present for that?
No.
Have you ever, are you aware if Collin was aware of that incident?
Yes.
He was aware?
Yes.
What about an incident where Kathy stabbed her then husband with a corkscrew and then burned him with a terrarium light? Are you aware of that incident?
Yes, ma'am.
And are you aware that Collin was present for that incident?
Yes, ma'am.
Are you aware of Kathy threatening to kill her then ex-husband's girlfriend's family in Homestead?
Yes, I am.
Are you aware that she actually started driving toward their house to follow through on her plan?
These are very leading questions.
Did you actually speak with her on the phone?
They're allowed.
I was telling her that what she was doing was crazy. She was going to get in trouble, that she couldn't take it out on 3 innocent lives in Homestead. She needed to turn around and go back home.
Are you aware if Collin was aware of that incident?
I'm not aware.
The incident where you said Kathy attacked your husband with a baseball bat.
Yes.
Are you aware if Collin was aware of that incident?
I'm not aware of that.
And have you ever personally witnessed Kathy engage in a physical act of violence towards Collin?
I know that there was a fight at the house in Port Charlotte, and the fight started because she was beating him with a belt and making him do push-ups, push-ups, and then holding a weight above his head while he was running in place.
Okay. When you say that she beat him with a belt, were you actually there for
Yes,
that?
I was, and I tried to stop it.
Right. What about, are you aware that Kathy pulled a gun on Collin?
Yes, and then later she said that originally she denied it, then she said yes. She pulled out the gun and handed it to Collin and said, just kill me, shoot me.
So she actually admitted that to you?
Yes.
And obviously Collin was aware of that because he was the one who was present with her.
Yes, and Corporal Rentus was aware of that also.
How was Corporal Rentus aware of this?
Because he and I and Kathy were talking about that. There's a difference when you take a gun out and give it to somebody and say, here, kill me with this, versus somebody pulling a gun out and putting it to their head or to their chest.
And so Corporal Rentus was a part of this conversation where Kathy admitted she pulled a gun,
yes.
And she said she handed it to Collin.
Yes.
Did she ever admit that she actually threatened to kill Collin with it?
No, she never did.
Within your family, you've talked about some of the family members. Despite some of the estrangements that Kathy had, would the family sort of maybe not talk to her for a while and then everybody would come back together, take trips together? I mean,
I was the constant in her life. My oldest daughter didn't talk with her while she was married.
Okay, what I'm asking about is, did the family talk about Kathy with each other?
Yes.
Okay, and whether or not Kathy was estranged from anyone at any one particular moment, did the family continue to have discussions about Kathy.
Yes.
And was there, did Kathy have a reputation within your family as being violent?
Yes.
Did she have a reputation as being unpredictable?
Yes.
And volatile?
Yes.
Despite all of this, did you still love Kathy?
Yes, very much, very much. I always wanted to help her.
So it's leading, but it's leading and it's loud because it's helping prevent the witness from stepping in the trap, the landmine of the dad being shot by Collin.
It appears that Kathy at times wanted Collin with her at all costs, and then at other times wanted nothing to do with him.
Yes, when
The
she
state might still object.
had Collin back for about a month, she spoke with me and she said, "Mom, I have to get up every morning at 6 o'clock, take him to school, and then I have to go back and pick him up." And I said, "You don't have to, let him ride the bus."
Okay. I'm going to show you what's been marked as Defense Exhibit 26 for identification.
Sorry, what number is that?
26. Will you read this and see if you recognize it as a text from Kathy?
She didn't recognize the last set of texts.
Yes.
And ask that Defense Exhibit number 26 be admitted into evidence.
Any objection?
No objection, Your Honor.
Will be received.
In this particular text,
Tasha, welcome.
it's Kathy saying she's done with this, and she can't take Collin to school anymore.
Yes.
So that was a specific example of what you just described to the jury.
Yes.
As part of this vacillating back and forth that Kathy seemed to have about whether she wanted to have Collin live with her or didn't want Collin to live with her, did you all agree eventually to a concurrent custody plan?
Yes, we did.
And that was something, did anybody force Kathy to sign those papers?
No, not at all. Not at all.
Were there times when Kathy wanted to cancel the 751 plan, the concurrent custody plan?
Yes.
And then would she change her mind back?
Yes.
Okay, so it's safe to say she wasn't consistent.
She was not consistent.
Obviously, Kathy owned a gun, right?
Yes.
Okay. So, at some point, did Kathy give her gun to you to have it out of the home in Fort Charlotte?
Yes.
Do you remember when that was?
Yes, it was it's right after the incident where Officer Rentis and Lacey got involved when Collin came back to the home. So that must have been somewhere in the October time frame of 2023.
Okay. How long did you have the gun at your home and away from Kathy and Collin's house in Port Charlotte?
Less than a week.
Okay. Why did you have it for less than a week?
Because she demanded that I give it back. She said, it's my gun, you can't have it. And I said, but we discussed with Officer Rentis and Lacey that I would keep it. No, it's my gun, you can't have it. And how do I know Nikki won't use it to kill you?
Okay. So Kathy got the gun back, and
Yes.
so far as you know, she had it with her.
She had told me that she had given it to her next door neighbor Melanie for safekeeping, and then a couple months later she said, "No, Mom, I lied to you. I've had it all along."
Okay. Finally, you had a lot of communication with Kathy on September 7th and September 8th.
Yes.
Right? You also had communication with Collin during that time.
Yes.
Did you allow Collin to go to your house in Auburndale when Kathy kicked him out?
Yes.
And why did you allow that?
Because a child can't be just roaming around the street by himself. Collin told me he didn't have gas in his car. You know, he had like half a tank, that was it. He didn't have his phone. He was using his computer somehow to talk with me. I told him, I said, you have to get to Auburndale before dark because otherwise the gates will be closed. During the day, the gates are open. And go in through the back sliding glass door because you know there's no lock on the back sliding glass door. And I will be there Sunday. Don't talk to anybody and don't leave the house.
At some point, obviously, Kathy, as the jury's heard on some videos, was trying to find out if Collin was actually at your house.
Yes.
When did she finally discover that he was at your house?
I let her know around 11 that night.
On the 7th, so
Yes.
Saturday the 7th?
Mm-hmm.
And how did she react?
She said, you lied to me. And I said, I told you I didn't know if Collin was there. I said, because I don't want you going over there and grabbing him. You just threw him out. Give him some time, give you some time. Let's not have a huge problem associated with this.
And aside from conversations that the jury has heard between you and Kathy over the next hours, did you specifically tell Kathy not to go to your house in Auburndale?
Yes. I said, I will be going Sunday morning. I left first thing Sunday morning. I was going to leave right then, but I was so tired and I have difficulty seeing in the dark that I thought, no, it's better that I wait. You know, in hindsight, I should have gone.
Renee, thank you for the super sticker.
So I waited, I talked to her, she said, no, Mom, I'm going. And that's when she said, I sold the car, they're gonna come by and pick it up. I said, you can't sell Collin's car, it's his car. No, I don't care, I'm selling it. I'm turning it into his probation officer for not, because he's not allowed to leave the county, which when I talked to the probation officer, I found out that Kathy had told them that I had terminal cancer, so therefore Collin could come and visit me anytime I want. I had to tell the probation officer, well, right now I'm only at stage 3, so no, you know, and I'm only in observation, so I'm not terminal.
Okay.
So,
but you personally told Kathy, do not go to Auburndale.
yes, I told her, I said, when I get back, I will give him gas money and I will follow him there, or we can wait until Monday morning. Let's just wait. Don't go there. You don't have permission to go.
Why did you not want her to go to your house in Auburndale?
because I didn't want her to start a fight with Collin. I was afraid that she would be combative, maybe go after him with a baseball bat, a gun, something.
I don't have any other questions, I don't think.
Thank you. All right, Cross. This could be spicy. We've heard Grandma's voice on phone recording.
I don't have any other questions, but Mr. Levine does.
Mr. Levine.
Thank you, Your Honor.
Spicy or mistrial. It could be both.
Good morning, Ms. Stedman.
Good morning, sir.
Ms. Stedman, I know you're going through a lot with the loss of your daughter and cancer and everything else, but I'm going to need to ask you some questions if that's all right with you.
Yes, sir.
Now, today here in court in front of the jury, you've talked about that you were concerned that Kathy was going to attack your grandson, and then you listed a bunch of different weapons. But weren't you more concerned that your grandson, who had killed someone before and had been violent countless times with your daughter, weren't you concerned that he was the one that was going to attack your daughter?
No. He had not been violent countless times with Kathy. Kathy had been violent with him countless times.
Now, a lot of the things you've said here today, you never bothered to tell me or law enforcement or anyone.
Objection. Judge, it's improper impeachment.
Ms. Detman, as it pertains to your grandson, do you talk to him a lot on the phone since he's been in jail?
Yes.
Okay. Do you do any emailing with him?
I don't email with him while he's in jail. No. Just talking on the phone.
Talk with him?
Yes.
All right. And how many times a week would you say that you talk to your grandson on the phone?
I usually talk to him 3 times. I encourage him to pray. I ask him if he's eating. I mean, I'm a dietitian, that's what I do. That he's drinking his milk, that he's exercising in his cell, and most important, that he's reading books. And I keep telling him, you have got to pray. You have got to read your Bible.
Now, I mean, this is an obvious question, but you love your grandson, correct?
Yes.
Your daughter is dead, clearly.
Yes.
And she's not coming back, correct?
No.
Now, would you agree that you don't want to see the defendant have to go to prison for a very long time? Is that correct?
I don't want to see my grandson go to prison for something he didn't do.
All right. Well, you couldn't make it any more crystal clear that you're up there and all your answers that you've given have been driven by you believing that the defendant, your grandson, didn't murder your daughter, correct?
I am giving clear answers, sir, as to what happened. I know my daughter. That's why I didn't want her coming that day to the house without me being there. I wanted her to wait the next day so that maybe she could calm down a little bit.
You know your grandson too, correct?
Yes.
And you know his history, correct?
Yes.
Now, careful here.
You say you know what happened, but you weren't there when it happened.
No, I'm not saying that I know what happened. I know the possibility of what could have happened. I wasn't there, so I have no way of knowing. I just know the facts about Kathy, having lived with her and worked with her, even to try to maintain her sanity, to try to maintain that she could keep her job as a teacher, to try to maintain that she wasn't trying to slice herself and kill herself, and not coming after my husband with a gun.
Okay, let's talk a little bit more about Kathy. Now, it sounded like she had some mental problems. Is that correct?
Yes.
Now, you would probably agree that it didn't help that she got impregnated when she was just a child, correct?
She was 13. She got impregnated when she ran away from the Hope House, and they found her in the hotel with her boyfriend. It didn't help that her father called her F bitches, and that She was damaged goods, and he didn't want anything to do with her.
Ma'am, it sounds like you're really quick to try to throw dirt on your dead daughter. Would you agree with that?
No, not at all. My dead daughter did the best that she could. We have a problem in this country with addressing mental health. We all know that. And that's what she had. She had mental health issues. At times, she was the greatest person on the world. Very intelligent.
I appreciate that, ma'am. I appreciate that. Now, your daughter worked as a teacher for many, many years, correct?
Yes, she did.
And her students loved her, correct?
Yes, they did, for the most part. I mean, as with any teachers, you're going to have some students that, I mean, I'm an educator myself. You're going to have some students that don't. For the most part, yes.
And she cared about her students, correct?
Yes, she did.
She had a passion and a love for teaching.
Yes, she did.
And she taught, predominantly she taught English, correct?
Yes.
And she cared so much about her students that at a certain point, she let one of her students move in when she was married to her ex-husband, Chuck, correct?
Yes.
And then, unfortunately for your daughter, Chuck took advantage of this underage student, is what is believed to have happened, correct? And
Judge, I'm going to object to the relevance of all this.
Whoa.
Approach.
Okay. I think it's very apparent that the state is trying to get her to open the door. Hold tight. We're going to skip ahead so we can be caught up at the last couple seconds. Okay.
so to your daughter, I can't.
Oops. I went too many seconds forward. There we go. All right. We're like 18 seconds behind, I think. This is crazy. I think he's trying to get her, to get her to be riled up and say something she's going to regret or not mean.
Miss Stedman, I'm sorry we have to talk about some unpleasant things, but it'll be over soon enough.
Thank you, sir.
No problem. So, do you recall my last question?
Yes. You were asking me why I was spilling dirt on my dead daughter, and I said I'm not. I said I supported her. I've gone into massive debt in trying to ensure that she had.
I appreciate that, but that was a few questions ago.
Oh, you're talking about how Kathy ran away from the Hope House and they found her in the.
No, I'm not talking about that either. But if you listen to my questions,
Just ask the question.
it'll get easier. So. We were talking about your daughter, that she was a very committed teacher and very committed to the youth of her classroom. And I mentioned that at a certain point, she even allowed one of her students to move into the household, and it was believed that Chuck had an inappropriate relationship with this student. Are you aware of that? With a yes or no answer, if we can start at that place, I'd appreciate it. Are you aware of that?
Yes.
And you were not a big fan of Chuck as it ended up being the divorce, correct? For how he treated her, from how he impregnated her as a child through the years, being physically, emotionally, and mentally abusive to your daughter. I can't imagine you were a fan of that, were you?
No, Robert was the one that was a fan of Chuck.
Now, ma'am, I understand that you hate your ex-husband.
I don't hate him.
Well, it sounds like you're throwing stuff about Robert in a lot.
You just asked me if I was a fan, and I wanted to tell you who in the family was. I knew Chuck from the time he was.
Ms. Stedman,
Oh, I'm sorry.
that's the point. He gets to ask the questions
I'm sorry.
to elicit the information he's looking for. If additional information is needed, Ms. Thornhill or Mr. Hendry will make sure to address it. So just pay close attention to the question that's asked and try to answer just the question that's asked.
I apologize.
It's all right. Mr. Levine.
Appreciate it. Ms. Stetman, as it pertains to your last piece of information that you provided, as it pertains to your husband, he hated Chuck for what Chuck did to his daughter, that being impregnating a little girl, correct?
I'm going to object to the relevance of and to speculation about what Robert thought about Chuck.
Sustain as to relevance.
All right, Ms. Detman, if I ask you a question that, for your information, just please answer it, irrespective of your feelings about your ex-husband, all right? Now, at a certain point, Kathy got divorced from Chuck, correct?
Yes, sir.
After years of unthinkable abuse, correct?
Yes.
Now, let's move on to a different subject matter. When your grandson lived in Oklahoma with his dad for about 3 years or so, at the end of that, your grandson wanted to come live with Kathy and actually was able to, correct?
Yes.
And Kathy was very happy about that, correct?
Yes.
And she felt that she had missed out, understandably so, on multiple years of her son's life, correct?
Yes.
And she was trying to fix or make your grandson's life better.
She was trying to improve his lifestyle, yes.
Now, you described it as a fight in Port Charlotte where law enforcement came because you said your daughter was beating Collin with a belt and made him do sit-ups and push-ups. You remember that?
I did push-ups. I took away the sit-ups. It was push-ups and putting the weights above his head and running in place.
Okay, thanks for clarifying that. Now, you remember talking to law enforcement when they came out there, correct?
Yes.
And giving a sworn statement because you just wanted both parties, your grandson and your daughter, you wanted everybody to be safe and healthy and happy, correct?
Yes.
Now, Ms. Detman, as to the root of what the issue was that night, do you remember telling the deputy that the three of you were at the dining room table and Susan had Collin seated down and Kathy told Collin that she would be implementing new parenting rules and Collin would be having his Xbox, his cell phone, and other items taken away as disciplinary action due to him being disrespectful to her. Do you recall telling law enforcement that?
I remember telling law enforcement about the Xbox would be, I don't know if it was taken away, but it was going to be restricted.
And at that time, your grandson didn't want to hear from his mom, and so he stood up and threatened to fight her and said, let's just do it, correct?
That was after the incident with the exercising and belt, the beating of the belt. That's when Kathy wanted us to all sit down and eat sandwiches. Like it literally went from one extreme to another. Sit down and eat sandwiches. And then Collin got up from the table and said, let's just do it. And I went to go get my phone to contact Officer Rentis or Corporal Rentis or Officer Lacey.
Okay, all right, very good. Now, you mentioned that you and your family members love to talk about how violent Kathy was. Is that right?
No, we didn't love to talk about how violent Kathy was. We talked about what we could do to help her. We didn't want her to lose her job. We didn't want her to be suicidal. And more than anything, we wanted her to try to get better.
Did you talk about how violent your grandson was?
No.
And why not? Weren't you concerned about that?
Objection.
Sustained.
Now, you were concerned about where the defendant would live, correct, in terms of who he might hurt, whether he lived with you and your husband, Nikki, or if he lived with Kathy?
My husband did not want Collin to live with us because he said that if Collin lived with us, Kathy would be over at the house and he didn't want to have to deal with Kathy.
Ma'am, didn't Nikki say he didn't want Kathy, he didn't want Collin to live with them because he was afraid that Collin might kill you or kill him?
No.
Diabetes, thank you very much for the super chat. Thank you.
All right, now let's move on to the subject matter of kitchen knives or butcher knives. Do you tell the jury about the time when you noticed that there was a knife missing from your residence there in Auburndale, and you were trying to figure out who stole the knife or who took the knife?
Yes, there was a small knife with a blade like this that I'd bought at the dollar store, which is now like the $1.29 store, and it
That
had
was
a
funny.
protective cover on it, and it wasn't in the drawer with the rest of the knives and silverware.
And did you find out eventually that your grandson had taken the knife?
Yes.
And he basically told you he just needed it just in case, and did not elaborate on what he was going to do with it?
He said he just needed it.
Now, at that time also, Kathy made it explicitly clear to you that she was afraid that the defendant might hurt her, correct?
Not at that time, it was later.
And there was multiple times when Kathy let you know that she was afraid for your safety and for her own safety.
Yes.
Now, you mentioned that a couple of things about the 7th and the 8th of September. You mentioned that Collin told you that he didn't have a phone with him on the 7th. Is that correct?
Yes.
Were you aware that he did have his cell phone with him and it was in his car?
So his cell phone had been turned off by his mother. She used to do that anytime she'd kick him out. She'd turn the cell phone off. In fact, it's in the records that she turned it off, and she turned it on, and she turned it off.
And you mentioned that the sliding door, that it had no lock on. Is that correct?
We had adapted the sliding door for a doggy door so Freddie could go in and out when he was staying in Auburndale, my acid house. And so it did not have a locking mechanism. You could close the door, but you couldn't lock it.
And so that's how you mentioned that your grandson was able to get into your house on the 7th?
Mm-hmm. Oh, plus the front door was. I don't believe in locks. I've been burglarized, and the burglars got in quicker than I could find my lock. I don't lock things.
Okay.
Please don't give her address. Please
Now,
don't give her address.
Your response when this was going on, when law enforcement made contact with you, was that you didn't know that Collin was a psychopathic killer, correct?
I never said that. Never.
If I may approach, please, Your Honor.
Uh-oh, here comes the impeachment.
And I'm going to show you page 59 of 67 of her statement on September 8th.
Let's see it before you approach.
I'm sorry?
I wanted you to see what he's
Thank you.
referring to before you approach.
I never said that. Never was her words. Something about Collin being a psychopathic killer. We now have a transcript that's being shown to the defense, and then will be brought up and shown to the witness. Just read to yourself.
Take your time and read the highlighted portion to yourself.
For one thing, I don't use words like stupid, Collin. I would never say that.
Oh, man.
He just wants you to
Oh,
read it to yourself.
okay. Oh, I'm sorry. I'm sorry.
That's all right. That's all right.
We may need to go sidebar real quick.
We may need to go sidebar.
Have you finished reading it?
Yes. Uh-huh.
Approach sidebar, please.
Okay, this is getting juicy. Hang on one second. Let's. I think we're gonna be when they say sidebar. I think they're going out in the hall. Okay, we are all caught up. We're up to the second. Wow. Now the transcript is wrong? We'll see. It could also be that that defense is aware that the statement that the witness is making is not true, and they have to correct the. They have to correct it. They can't let a witness knowingly falsely testify on the stand. That would be very bad for their license. YouTube Premium has an experimental feature to go up to 4x speed. Oh man, that's quick. That's really quick. My wife will love it. I just finally signed my wife up on our YouTube Premium account, so that there's weird stuff moving around on my screen that I'm not moving, so that she can skip advertisements. I keep telling her I don't want her to use my account because that would change my feed to be full of her crafting videos, which are great, but I don't have much interest in them. But finally got her set up, so now she has no more. Now she has no more advertisements. 4x speed is for West Virginia trials. Yeah, that's worth trying YouTube Premium all by itself. 4 times speed. Do you know how quick we could get caught up? We could watch 4 courts a day. Like 4 full day trials in one day. We wouldn't get anything out of it. It would all just be gibberish. Oh. Trials by Alvin and the Chipmunks. How is this not hearsay? It's being used. It is an out of court statement by the witness, and it's being used for impeachment. So this would be I think proper. It sounds like proper impeachment, especially if it was a sworn statement. Shelly Kelly, did I miss something? Does Mrs. R.A. have a channel? She does. She has a channel. She doesn't do a lot with it. We might do a Q&A here on her channel here soon, the two of us, because a couple of y'all have requested that. But her channel is called Homeschool Ground Zero, where she talks about homeschooling our kids. There it is. Thank you, Samantha. Not sure how I feel about this grandmother. Lady and Great. She's been consistent with her testimony so far and very clear on it, but it also is very it's very opinionated. It's not just factual; it's opinionated, and coming across with a definite bias. Here, where she's made a very firm statement that she's never said that Collin was a psychopathic killer. That might come back and bite her. If we listened at 4x speed, we'd have to have Mrs. R.A. translate. Mrs. R.A., not only does she watch at 2 times speed, but she watches 2 things at once at 2 times speed. Like she'll do picture-in-picture windows and have completely different things, like a movie in one corner and another video in the other. And it's, well, she's drawing, and she gets it all. She just absorbs it all. Still haven't heard any proof of Collin's bad behavior. Here's what I want to say about Collin and about what the defense is doing. All the defense needs to do is introduce doubt. They need to introduce the possibility that what happened there in the grandma's house between Collin and his mom could have been a fight. Could have been a fight where it actually went down the way, as improbable as it was, the way that the defense is saying. That's their win. That's what they need. They've already introduced that this is self-defense. They have the burden to raise that, but once it's raised, then it becomes the burden on the state to prove that it was not self-defense. I think they've got some good stuff that they could do that with, but let's see. YouTube Premium is amazing. I heard creators get more benefit too. We do. YouTube does. If you have YouTube Premium and you're watching, first of all, you don't get commercials, and second of all, YouTube will split. They'll look at everything you watched for the month, and they'll split your YouTube Premium membership cost. Like they'll take half and they'll take the rest of it and split it between all the channels you watched. And believe it or not, it is quite significant. It does add up quite a bit. Kim, I sprung for like the 20 something dollar version because it has me and it's a family account. So I have myself, Top Mark Media, Mrs. R.A., a couple others, so that all our different accounts that she uses, she does use different accounts for the school videos that she shows. So we just don't get advertising on any of those. Yeah, you pay the £20 for YouTube Premium, and you can add 5 people to your account, and they all get the benefit. It has to be 5 people in your household, and they can tell. Believe it or not, they can tell. Oh, Sherry, oh my goodness, that's never a fun day when the plumber has to come out. Hopefully it's a quick fix and an easy cleanup. Kathy, no. I call her Jen. I just don't know what the tax was on it. I'd have to look at the price. Let's see, I'm cutting out. Test 1 2, check 1 2, test. I'm a little quiet. Test, check 1 2, test 1 2. Now I'm really loud. Test 1. Yeah, I don't want you to hear me breathe, but test 1 2. Check. Is that better? Is that too loud? The headphones Collin's wearing right now allows him to hear what the judge and the lawyers who have approached at the sidebar are talking about. Yes, Jen is for Jennifer. Yeah, if you watch a lot of YouTube, I realize, first of all, it's expensive. I'm all about, we don't have cable TV, we don't have antennas, we don't right now, we don't have Hulu, we don't have Netflix, we don't have Disney Plus, we don't have Peacock, we don't have any other streaming service. So all we have is YouTube. Yeah, I'm trying to keep the ASMR down, but my volume loud enough. You weren't cutting out, now you're loud. Okay, it might be just be on your side then. Yay, JVA. That's awesome. I take it the defense lawyer stayed at the desk to continue to block the camera's view of Collin. He has been very effective at that since day one. Day one, he did not. Day one, Collin scooted all the way up to the table and was quite visible, and the camera zoomed in a lot. There weren't any objections about that. We have had other trials like Koberger, Lori Vallow, let's see, the ski slope, Gwyneth Paltrow civil case. We've seen cases, trials, where defense or prosecution makes a big deal about zooming in, and they haven't raised that as an issue. They just have their own solution, which is you just scoot back a little bit and you'll be hidden most of the time. Of course, he isn't right now. Jasmine, thank you. I try to make the audio the best we can. This one, all we had to do is take the top end because there's a little bit of a hiss. There's a hiss in the audio that, and there's also a low end fan. There's some probably an air conditioner or a mover to keep the air fresh. That I've taken those two sounds out, but other than that, it hasn't needed a lot of work. Raising the levels a little bit as well. But we do antenna for local use. Oh, I don't even have an antenna. The only TV we have in the house is the one that I use for my big screen over there. That's it. It's a logical argument to me the camera should view only what someone's in the gallery sees. Or I can see that argument. but I don't like it. I don't like it. It's true when a court is talking about being open to the public would not get to see as much as we get to see because of that. Not listening to music, listening to the sidebar, which is not a band. Samantha, R.A., do your children go to school once they reach a certain grade level? Yes, they go to college. We have 3 in college now that have all been homeschooled. So I get benefits from YouTube Premium. I do. I would tell you the benefit I get from people who have YouTube Premium watching my channel is more than the benefit I get of people who don't have Premium and I get ad revenue. The ad revenue is less than YouTube Premium revenue, like per viewer. Does that make sense? It's more beneficial to me as a content creator if you have YouTube Premium. I think the camera should be focused on the speaker, period, full stop. Yeah. I'd prefer to have the view the jury gets. I'd love to have a view from the jury's perspective of the entire trial. I think that's like perfect, right? Because you get to see the judge, you get to see the witnesses, you get to see the evidence, you get to see the defendant. Looks like we're done on the sidebar.
All right, thank you, Ryan. Ms. Stedman, we're almost done, all right?
Thank you.
You're welcome. Ms. Stedman, is it a fair statement that Kathy had expressed to you that she was getting very frustrated with the fact that your grandson wouldn't do his chores, was disrespectful, and was basically just taking his mom for granted?
Yes.
And when Kathy was communicating with you on September 7th and September 8th, that was the Saturday and the Sunday, she did so by both text messages as well as phone calls, correct?
Yes, sir.
And Kathy made it clear that she wanted your grandson home by 10 a.m. on Sunday, correct?
Yes, sir.
And then when that didn't happen, when 10 a.m. came and went, she still made it clear that she wanted your grandson to come home, correct?
Yes.
And Kathy mentioned that she wanted him home. She wanted him to go get work at Domino's from like 4 or 4:30 to 8 or 8:30 on Sunday, correct?
Yes.
And your grandson was working at Domino's, correct?
Yes, he was.
And so Kathy wanted him home so he could then go to Domino's that night, correct?
Yes.
Looks like state lost that objection.
And then kind of towards the end of the communications, then Kathy told you she was going to your house to get Collin to come home, correct?
Yes.
And she told you that either he could go home with her or he could drive, basically follow her in his car, correct?
Yes.
All right. Thank you for your time today, Ms. Stedman.
Thank you.
I have no regret.
Is the witness released?
Yes, sir.
Is her name, is she released?
Yes, sir.
Thank you.
Thank you.
Interesting. They cut that one short. Turned down the spice quite a bit.
Any other witnesses or other evidence you wish to present?
No, sir. That's right.
Rest.
Defense rests.
There being a rebuttal, Mr. Levine.
Whoa.
No, Your Honor.
No rebuttal. Holy cow.
Ladies and gentlemen, both parties have rested their cases. The next phase would be closing arguments, followed by your instructions on the law, and then deliberations. Closing arguments in these types of cases are typically not short. Also, I need to have a conference with the lawyers regarding the jury instructions, although it is up to me to decide what laws apply and how you should be instructed. They do have a right to give input. That conference could take some time. So if we did all of that in closing arguments, we would be sending you out probably
Camera got lost there for a
mid
minute.
to late afternoon, and I don't want to do that to you. So I'm going to give you an early day today, and we are going to work the rest of the afternoon to get all of those strings tied up so that tomorrow morning we'll begin directly with closing arguments, and then the instructions will already be finalized, and you will be probably going to deliberations around lunchtime, I would imagine. So you're going to have an early day. Now, although you have heard all of the evidence, actually I'm not quite sure about that. Give me just a moment. Would you approach just sidebar real quick?
The judge is like, are you sure you don't want to call one more person? Is there anything they need to hear? Is there any videos? Wow, this accelerated from it went fast, it got spicy, and then they turned down the heat, and now we've been set aside to simmer for a day. I have to tell you, this is sort of good for me because we have a sentencing in the ice fishing trial.
Our schedule, ladies and gentlemen. So before I dismiss you, I just need a few minutes with the lawyers outside your presence. So if you would just wait for us in the hallway for a moment.
All right, please.
We've got the sentencing in the ice fishing trial. Mr. Tanner is being sentenced. We've got that ready, all queued up to watch with you today. Then this afternoon, I told you I'm doing an interview with Courtroom Confidential. We did it before, and we had a technical issue. It has to be reshot, so we're reshooting that this afternoon at 4. And I'm actually going to be on. I think I'll be on the live stream with them Wednesday night. From like a half-hour short one. But Megan Boswell is in jury selection right now. They've got 1,200 jurors.
Mr. Griffith, would you raise your right hand?
Lined up.
Do you solemnly swear or affirm the testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor. He's not going to testify.
All right. I did not ask you about whether or not you wanted to give testimony in this case, so I need to talk to you about that. I assume, based on your lawyer having rested, that you did not want to testify. Is that correct?
No, Your Honor.
That's not correct, or no, you did not want to testify?
I did not want to testify, Your Honor.
And have you talked about that with your lawyers today?
Yes.
Have you talked about it with them on more than one occasion?
Several, yes.
And did they answer any questions you had about whether or not you should testify and address any concerns you had about doing one thing or the other?
Yes, Your Honor.
All right. And do you need any more time with them before you answer my question in a few minutes about whether this is your final decision? Do you need any more time with them?
Take a minute.
All right. So he can, Mr. Larson, if he can take them to the jury room.
47, 49.
Where's the jury? Isn't that where the jury is? You're taking him into the jury room? Okay, so yeah, we might not be done. We might not be done. I'm telling you, the defense thinks they're done. So if right now he comes back and says, I'd like to testify, it is against the defense's advice. And I also think that it would be bad for his case. It would be bad for his case. A 17-year-old against an experienced lawyer, the cross-examination would shred him up and spit him out. Oh, man. They just had the jury walk out. He said because this has to be done outside the presence of the jury. Yeah, he should not testify. That's generally true for any defendant. He can still be charged for his dad. That is true. It is possible, although I would say unlikely, that he could walk free from this one. Well, and I'm only saying that because his family life was quite rough, and there may be jurors who feel that that he could have been defending himself.
Just a few minutes, I assume, as long as you wanted to talk some more with your lawyers about this, correct?
Yes, Your Honor.
And did they answer any additional questions or concerns that you had?
They did, Your Honor.
Do you have any questions of me about your right to testify versus your right to remain silent?
No, Your Honor.
And it is your right to remain silent, and I'll be telling the jury that they're not to be concerned by that or view it as an admission of guilt. But one thing I need to make certain of is that you understand that this is your choice in this case. You understand that?
Yes, Your Honor.
There are many things your lawyers can do without your permission, things they can do that you disagree with, even things that you speak up and tell me you don't want them to do, but not this. You understand?
Yes, sir.
Have they explained that to you, that no matter what they think, it's your decision?
Yes, sir.
Now, they are supposed to give you some advice and counsel about what they think you should do. Are you satisfied with the advice and counsel they've given you?
I am.
And today, are you under the influence of anything, drugs, alcohol, or medicine?
No.
And any concerns related to competency? Have any of those arisen over the weekend, Ms. Thornhill?
None.
Mr. Hendry?
No, Your Honor.
And has anyone, including either of your lawyers, promised you anything or threatened you to keep you off the witness stand?
No.
This is your choice and your choice alone?
I know, Your Honor.
Is it?
Yes.
And you do not want to testify?
I do not.
Anything else you want on the record?
No, sir.
Mr. Hendry?
No, Your Honor.
All right. Okay, we can have the jury. I find that your choice is freely, knowingly, and intelligently made, and that it's made upon the advice of competent counsel.
And Your Honor, we're not raising additional argument on judgment of acquittal, but we would maintain our previous motion.
All right. Same rule.
All right, we're going to go ahead and end this poll. Looks like we've had about 520 votes on it. Is Collin Griffith guilty as charged? Oh, now there's some more coming in here. Just a simple yes or no. I have a spam call. I can't take it right now. The jury's on its way in. Call back later. Call back later. All right. 565, 568. We're ending it right there. With 576 votes, it looks like we have 87% say yes, guilty as charged. And those charges are kidnapping and premeditated first-degree murder. No would be 12. So obviously there are people who said no who might think that he's guilty of a lesser charge. Or there are people who think that he may be guilty of kidnapping but not murder, or murder but not kidnapping, or some other, I would argue a smaller contingency that might say he's not guilty of any of the crimes or the lessers. So a couple different answers all grouped into that for sure. All right. Joe, I don't know if he's going to get away with something. The way our justice system works, the jury has to basically be convinced beyond reasonable doubt that he is guilty. And a reasonable doubt could exist if you say, are the pieces there that would support a story that's different than what the state's telling us? In the defense's case, they say that his mom attacked him. What do we have so far? We have recorded statements, phone calls, body cam, everything else. We have a lot of evidence that shows all the medical stuff that she did to his dad, the corkscrew, the driving her car and pinning him against the house. There's firearm testimony. There's a lot that shows that his mom, the victim in this case, was the aggressor was very aggressive in several different other situations. I wouldn't say that we don't know if she started them or not, but there's a lot of evidence that shows that she had the capacity to do some pretty violent things. There was what I would believe is some testimony of abuse. The whipping with a belt while forcing him to hold a weight over his head, marching in place and doing push-ups. I think that goes into abuse. So if that possibility is there enough for reasonable doubt that, I don't believe she fell on the knife. I don't. It doesn't make sense with where the arms would have to be, with everything else. Second degree, in a heartbeat. First degree, most likely. But I don't believe accident. Now do the poll again, saying, will the jury find him guilty? The numbers would be very different. I always like to get your take instead of what you think the jury will do. But we might do that. Jury saw the medical photos and the neck wound. She didn't fall on the knife. She'd have had to fall sideways, perfectly on the knife, to have it go straight through with the knife up. It's crazy. Him dragging her inside, that takes the self-defense away from me. I think the thing that shows that they did not, that she did not want to be in there fighting with him, was that she was trying to get him out of there. That she wanted him to leave. She was throwing his stuff in the car. She had been in. She wants him out. You're coming with me. You're coming. Then attacking him in the house. It doesn't stand to reason that was right for me. But yes, Nenny, there is. I would say there's evidence of her being abusive towards him. I would think there's enough recorded phone calls just on the cameras alone at their home that there was at least verbal abuse. But at the same time, I think she honestly may have had some struggles with her mental balance. It sounds like she'd flipped a lot from one extreme to another. Did the ME testify? Yes, he's Irish and he's amazing. You have to go back and watch it, Valerie. It was on Friday. ME said homicide. It's crazy. They're just waiting for the audio from the courtroom as the jury comes back in. Both sides have now rested. We're going to be in closing arguments tomorrow. Jury's about to be excused right now. Courtroom sound is off right now. We're waiting for the jury to come back in. Here we go. Now it's back on.
Please be seated. All right, ladies and gentlemen, as I was saying, although you have heard all the evidence in this case, you still have not heard the arguments of the lawyers or the instructions on the law. So remember, it's not time to think about how you might decide the case or to formulate any opinions about the merits of the case. Also remember to avoid the news as I previously instructed you, and to avoid talking about the case with anyone or looking anything up. Now, tomorrow you'll be receiving this case for deliberations. I want to remind you that a jury may deliberate as much or as little as it feels necessary to that particular jury to do so. But what that means is that it's possible your deliberations could go past 5 o'clock if that's what you all agreed to. It could be earlier than that, but the point is you may want to let those who would normally be expecting you after 5 o'clock, that if you're not home, that the jury has chosen to continue deliberating. So just keep that in mind. Also, if you've been bringing your lunch during jury service, you may still do that, but I want to advise you that the court will be providing you with lunch tomorrow, because I anticipate you will begin your deliberations around lunchtime. And that way you won't have to separate, because you won't be allowed to deliberate unless you're all together at the table in the jury room. That will facilitate your deliberations beginning as soon as possible. So I hope that you enjoy the rest of your day, and we will see you tomorrow morning at 8:30.
All right.
Jury's now being excused for the day. There will be some, probably a jury instruction conference that goes on right now as they prep the instructions the judge will give the jury just prior to closing arguments, as well as the verdict forms that the jury will be using, which we'll talk about. If any lesser includeds are going to be on the table. So that's the work that will happen in court this afternoon before we have closings tomorrow. We do have another trial. We have a sentencing from a trial we watched. Seems like it was months ago. The ice fishing trial.
Did you want to break before we take up jury instructions?
Whatever the court's desire.
I'm ready now.
All right. I want to make sure everyone gets a sufficient break before we start that, especially.
I'm going to do a poll and see if you guys want to watch jury instructions or not.
5 minutes for a comfort break.
All right, I probably spelled everything wrong on there. I typed really fast. The poll is, should we watch jury instruction conference or ice fishing sentencing? Looks like ice fishing is taking an early lead, and a commanding one at that. Remember, the ice fishing trial was where Tanner, is it Tanner Carr? I can't remember his last name. Tanner, neighbors didn't like each other. Tanner slept with the defendant's wife, or the victim's wife. Yeah. And I don't know how you can get around that. That's basically the beginning of this. And let's see. Tanner slept with the friend of the victim's wife because it was the dad and the friend that fell in the water. It's a bizarre case. It's a bizarre. Some of the spiciest. Tanner Cody Carr, that's his name. Thank you. Thank you. Was it Leggy Bear? Teddy Bear. There was. I put an L and a G's on your name, Teddy Bear. Sorry about that. Leggy Teddy Bear is what we have. It's a wild, wild case where he has an airboat and people are jealous of him, and he's got a girlfriend that, lies for him, and it's wild. It's the only trial where it got so spicy I literally poured water on myself. It was getting hot in here. It was getting pretty see. Okay, we're going to end the poll. It looks like ice fishing is where we're going next. So we're going to do that now. Let me see. It's going to come in on 6. Let's jump to 6, shall we?
This is Tanner Cody Carr, file number 247107FH. This time of day set for Mr. Carr's sentencing. He is present, represented by Attorney Guy Cotter. People are represented by Assistant Prosecuting Attorney Alexander Pani. On December 4 of last year, a jury of his peers found Mr. Carr guilty of 3 counts of assault with intent to do great bodily harm, less than murder, felonious operation of a vessel, and reckless operation of a vessel. Ms. Karen Eberlin has prepared a pre-sentence report. It's dated January 8th, 2025. There have been sentencing memorandums that have been submitted. The court has reviewed those documents and the documents as well. And Mr. Cotter, have you and your client had the opportunity to review the pre-sentence report?
We have, Your Honor, and we do not have any deletions or corrections at this time.
We'll go back and catch the rest of the jury conference once this is done.
Any objection to the report as well as guidelines?
None from the people, Your Honor.
Thank you. Any objections to scoring the guidelines, Mr. Collin?
Your Honor, I have thoroughly reviewed the scoring of the guidelines, and they are correct. No objection.
Very well. Is there anything you'd like to say on behalf of the defendant or the court imposes sentence?
Yes, Your Honor. Mr. Carr is here, 38 years old, as you can see. Mr. Carr is his family. He has a large family. He has a large group of friends, a lot of community support. In the sentencing memorandum, we provided letters of who Mr. Carr is as an individual.
Audio's terrible.
He's a fiance, he's a father, a son, brother, friend. Court knows in the Compass assessment that in the pre-sentence report, many of the Compass assessment categories show up as unlikely, meaning that Mr. Carr something like this will never happen again. The only thing that was positive was vocational education, which says will be assessed on incarceration. All these are positive behaviors that Mr. Carr currently has. This was an isolated instance, Your Honor. This was not a character of who Mr. Carr is. As I've got to know him over the course of a year since this began, he's become more of a friend even to me.
We go out fishing
Your Honor,
together.
part of the pre-sentence or the sentencing memorandum that the people have provided goes into thorough detail about wanting the guidelines to be between 38 and 120 months for Carr. That is really excessive in my opinion, based off of one event. They mentioned the fact that Mr. Carr has all these misdemeanors. However, in the Slate Act, Mr. Carr has had all of those misdemeanors set aside automatically. So the only convictions that he has on his record are these felonies along with this high court misdemeanor. In addition, Your Honor,
he's got all these misdemeanors set aside.
Case of People versus Snow. In that case, Your Honor, they rely on the fact that they're trying to send a message to the community stating that certain types of behavior shouldn't be happening because it's repetitive. Well, in People versus Snow, in which the people rely, the reason why there was an extensive sentence for Mr. Snow, the defendant in that case, was because there were 234 convictions for people escaping the Jackson prison. That is nothing like this case. This was an isolated, single event that was before this court. Additionally, Your Honor, that part of the pre-sentence report mentions the special alternative incarceration program. We'd like the court to consider that for Mr. Carr. We think it'd be beneficial. They state that the court does have a little bit of discretion to get on the record placement if overall, Your Honor, Mr. Carr is apologetic. The community, victims, his family, many of the letters of support, as I stated, for who he is as a person. That's how they don't see him as.
So the lawyer's making this statement. We can barely hear him, but he's trying to say that the defendant is very good. Good person, nice, good friend. Would never happen again.
With everything that is transpired, everything that has been provided to this court, the letters of support, the lack of history for Mr. Carr, the fact that we're here today, we're just asking that the recommendation of the pre-sentence report follow today.
Okay, he wants on the lower end of the.
Does your client wish to address the court?
Yes, Your Honor.
Okay, this is more meaningful.
I want to say sorry for stuff that's happened and heartache that has happened to the families. And thank you for taking the time to do it and allowing me to be out with my family with the tether.
With a tether.
On behalf of the people, and this is a victim's rights case.
Yes, Your Honor, and pursuant to the Crime Victims' Rights Act and Amendment, Mr. Kenneth J. Lasesky wishes to address the court. Mr. Kenneth A. Lasesky has drafted a letter which he has asked the people to read, so if the court will hear from Kenneth J. Lasesky.
That's fine. Morning, Mr. Lasesky. What would you like to tell the court?
Morning, Your Honor. I just, in a sense, have dealt with this situation for the past 9 years. As Mr. Carr stated in the trial, that the incident that arose this was because he had an affair with my wife. And I don't think that it's over yet. The way he's been acting, I've still been having his associates flip me off on the side of the road when I see them. And my father hasn't been able to go out in the cold weather because he's got damage to his hands. We tried fishing last week and he had to walk off the ice. He has permanent damage. I've been dealing with this for 10 years and I just want you to consider that in the sentencing. My family's had a lot of damage and I just hope that it's over.
Anything else?
That's it.
Thank you, Mr. Lasesky.
Thank you.
Your Honor, and just for the record, the third victim in this case, Mr. Craig Grimmel, is present. He does not wish to address the court at this time, but I will read into the record a letter drafted by Mr. Kenneth A. Lasesky. And he writes, Your Honor, one thing I love to do is ice fish. I don't do any other fishing. I wait every year for ice. It has been a father and son tradition since Kenny was about 4. We went every chance we could. We went to Canada, up north, didn't matter. We went together every year. But since last February, things have changed for me. I was always one that could come home from work, grab my gear, and go sit on the ice till dark if I wanted. The cold did not bother me. But now it's not the same. I'm lucky now if I can last an hour. My hands start to hurt and get so cold that I can't hold on to nothing. My legs also get cold fast, and I wear the right clothing to keep my body warm. I've gotten so cold now I just shake and have to quit and just go home. Even at my job now, I have to dress differently because now I am cold. This is very disappointing to me because I cannot enjoy what I used to. I want to know if this is my sentence for the rest of my life, while Tanner has been able for the past few months to enjoy himself fishing, hunting, ice fishing. He can enjoy himself because nothing has bothered him. He has no regret that he has injured me in any way. Your Honor, I would like you to take all this into account. I would like to see that Tanner will have to sit and think of what he actually did. He needs to be accountable for his actions. He has lived his life so far getting away with things and has the opinion that he can get out of any trouble. He needs to learn that there's a right and a wrong way to live and that there are consequences for our actions. Your Honor, on behalf of the people, the court has reviewed our sentencing memorandum and the court had the opportunity to hear the testimony and to listen to the facts that were presented to the jury in this case. What should have been an enjoyable morning of ice fishing turned into a day of terror for these 3 men who were simply out trying to enjoy what Huron County has to offer. They were together, they were enjoying one another's company, and all of that was ruined and destroyed by Mr. Carr's actions on that day. Senselessly and needlessly, Mr. Carr pulled into that cut, destroyed the ice, and only by the grace of God, Your Honor, are we here not for a homicide sentencing as to Mr. Kenneth A. Lasesky, who barely escaped the water with his life that day. It was only due to the quick thinking of his son and Mr. Grimmel and a passerby that they were able to get the elder Mr. Lasesky out of the ice in time to save his life. Your Honor, if any case comes before this court that deserves top end of the sentencing guidelines, this is it. This may be Mr. Carr's first felony, but what a serious felony it is. Again, it is a miracle that these 3 men are here in court today before Your Honor, rather than in a cemetery. Mr. Carr must be held accountable for his actions. And Your Honor, despite his words here today, even while he was on bond, he was before this court for a bond violation for thumbing his nose at the court's order to stay off of boats. Couldn't do it. wouldn't do it. There is no reason to believe that Mr. Carr will be successful in any SAI programming because of the fact that he wasn't successful on bond. He doesn't believe that he's done anything wrong, but Your Honor, the jury has spoken. Mr. Carr must be punished for his actions, and his future actions must be deterred. And that is why we are asking the court to sentence him to 38 months in the Michigan Department of Corrections to the top end of 10 years.
38 months to 10 years. We didn't follow this trial in December. It was spicy.
Your Honor, I'm sorry to interrupt. I would also add that just as a note, the people did include the notice that of a felony committed with a vessel, and we would ask the court to enter an order that will direct the Secretary of State to prohibit Mr. Carr from operating a vessel on the waters of the state pursuant to statute.
Whoa.
What's the length of that? Do you know?
There is no interim in the manner that that statute was written under the Department of Natural Resources Code.
For life.
So it's discretionary with the court.
It is, Your Honor.
They're trying to take away his ability to fish.
Any other comments?
And a few other things.
Yes, Your Honor, I'd like to, again, go back to my sentencing memorandum. Quoted to Michigan versus Doolittle. Case that I quoted in that. The Michigan Court of Appeals in that case found that facts were a man who beat, strangled his girlfriend was probation, because what we were trying to do, or what the Michigan Court of Appeals was trying to accomplish, was to rehabilitate. And
he's citing other cases. That wasn't in this case.
That people change. We're asking for the special alternative program for Mr. Carr because people can change. They can be rehabilitated. They can be, there can be a prevention of recidivism. We're asking for that today. We're asking for the minimal, or actually the recommendation of the Michigan Department of Corrections to 2 years and 2 months stated in the report. This will never happen again.
They want 2 years and
Carr
2
has learned
months.
through experience that this is something that affects not only him, but affects his family, his friends, people that surround him.
It'll take away his fishing licenses with a felony.
We're asking that.
Won't be able to hunt and fish.
Report, recommendation of the board.
Thank you. Mr. Carr comes before the court 38 years of age, no prior felonies, 8 prior misdemeanors. Court heard the trial, and I used to ice fish out there when I was a kid too, back in the day, years and years ago. It's been a long time. And as a kid, when your father would take you out there,
Judges just
it
off
was
to the
neat
right.
just to get out there, number one, but number two, to traverse across the ice, get to your spot, drill the hole, enjoy the day. Hopefully you get something and it makes it a good day. That's what the Leseskis intended to do that day. And it sounds like Mr. Carr did as well at one point, but obviously there's been this, for lack of a better phrase, bad blood. Let's just be honest. There's been an internal feud going on regarding something that happened a number of years ago, which I'm not going to delve into.
He slept
because
with Kenneth's wife.
We need to move on from that. Everyone needs to move on from that. You hear the victim state as part of victim impact statement that he's still impacted by this. His family's impacted by this, family and friends of the defendant. And, you know, it's real easy for the court to say, hey, come on, let's just stop it and get along. That'd be the easiest thing to say. But I understand. And unfortunately, though, it's one thing to flip someone off. It's another thing to potentially cause them to lose their life, frankly. The elder Leseski doesn't swim. I couldn't imagine being out on an ice floe like that. And really, there was just no justification or excuse for it. Just turn the airboat around, get out of there, stay away. This would have been fine. What I find most troubling, though, about this is beside the fact that the act occurred, testimony was presented during the course of the trial that the defendant had asked, if I recall correctly, girlfriend to monitor scanner traffic. And the testimony from the defendant was, well, I wanted to make sure he was okay. Well, common sense would dictate otherwise. That is, if I
That's
created
a
a
crime.
situation like that, I should go out there. That didn't happen. So that shows me the bad blood, really, to the court. And that's unfortunate because I couldn't imagine being in the situation that these individuals are in. But to make it that much worse, there's no excuse or justification for it. The court has reviewed sentencing memorandums. The court has reviewed the letters that have been submitted. And the court is going to adopt in part the recommendation. I'm going to move backward from it. As to count 6, the marine safety, reckless operation of a vessel, maximum sentence that can be imposed, 90 days in the county jail, credit for 1 day served. Count 4, marine safety, felonious operation of a vessel, will be the sentence for the defendant served 365 days in the Huron County Jail, credit for 1 day served. Relative to both of those counts in the operation of a vessel, the Secretary of State will has the authority through the court, because a vessel was used during the course of this felony, that was the felonies committed by the defendant. The court will order a 10-year prohibition of the defendant operating a motor vessel. And that is going to be actually to count 1.
10 years.
I'll get just at that.
He can't drive a boat for 10 years.
As to counts
That's operating.
1,
He could
2,
be on one.
and 3. Court is going to order restitution to Kenneth Allen Leseski in an amount to be determined. We need to have a restitution hearing on that. The court can schedule one. Defendant is to execute a wage assignment to pay the restitution if he's working and misses 2 regularly scheduled payments. Crime victims assessment of $130 will be ordered. DNA testing fee of $60. State cost of $322. As I stated, the commission of a felony with a vessel, advisory, a 10-year prohibition, an operation of a vessel. Finally, it will be the sentence of this court that the defendant be committed to the Michigan Corrections Commission and placed in the commission's custody for a period of not less than 2 years, 5 months to 10 years with credit for 1 day served. That is as to each count. That is the midpoint of the guideline range. It is not the low end. It is not the high end. Defendant has no prior felony record, but let's be honest, he committed a really boneheaded move that day. And I mean no disrespect by that statement, sir, but I couldn't imagine leaving someone out in the water like that. So the sentence will be 2 years, 5 months to 10 years, credit for 1 day served as to all 3 counts, which shall serve concurrently with each other. I hope you learned from this, sir. I hope that when you see these individuals or see any other individual you may have not the best relationship with, is just simply walk away. By doing so, you'll avoid this situation. My duty to inform you of the right to seek leave to appeal. If you're financially unable to provide counsel of your own choice, court will assign counsel for a public expense. Please initial the receipt and questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the clerk of the court within 42 days.
That's it.
Your Honor, this morning we did receive a receipt for medical expenses from Mr. Leseski. If I may approach the court with that, I've tendered a copy to Mr. Cotter. The amount of out-of-pocket expenses, $146.02.
Did you receive, I'm not doubting Mr. Pahani, but for the record, you've received it. Or we'll order that as well. You may present that.
Thank you.
$146 of medical expenses as a result of this.
All right, so regarding restitution to be determined, but the court will also order the 146.02.
Okay, so 2 years,
As to
5 months.
the alternative, the program at this point, the court is not ordering. That'll be all. Thank you.
That'll be all. And they're done. That's it. Okay, so we got the bookend. We're going to jump back to the Collin trial, but let me just say what just happened. need that button pushed. Okay, so he nearly killed people. He drove his boat. It's an airboat, so it's like a swamp boat in Florida, but they use it on ice up in Michigan. He drove that down what's called a cut, which is like a little channel off of a lake. They were fishing on that channel, and he drove up to them and was like, "Hey guys, you caught any fish?" And they just he's the guy who's fishing is like, "Look, you slept with my wife. I don't want to talk to you or tell you about the fishing in this area." And so they give the bird to each other. I don't know what happens, but he gets mad and he runs his airboat down that cut. The guy whose wife got slept with sprints away, makes it to shore and hides behind a rock. And so he swerves around and goes back the other side. So he's gone down one side and up the other. It breaks up all the ice. The weight of the airboat broke up all the ice with the other two guys, the victim's dad and friend, in the middle. And they fell through trying to get off. Or one of them fell through, I think his dad. And his dad, as it's reported there, has suffered some damage from the amount of time he was in the water, it's terrible. I mean, if you've ever been in water that cold, it is unbelievable. I mean, it hurts. It hurts. It's so cold. So did some pretty nasty stuff. Then he took off. He lied about it. He said he was with somebody else, told them to lie about it. His girlfriend lied for him. He lied to the cops. When the cops came to his house, we've got body camera footage of him just going off on the whole situation and the whole sleeping with each other's wives. And he was trying to sleep with my wife, but I slept with his wife first, and now he's mad about it. It's pretty crazy. It's the spiciest of all spicy. Anyway, he's sentenced to 2 years, 5 months in prison, and it's 2 years, 5 months up to 10 years. So it seems like if on good behavior, he'll get out at that time, or if he's not good, he'll get out after 10 years. And then after that, he has 10 years where he's not allowed to operate a boat. Because he's got a felony on his record, that may also impact his ability to get a license to hunt and to fish in the state of Michigan, which are the two things he wanted to do. So that's probably one of the largest punishments for him. But we're going to jump back down to the jury conference, which is just beginning. We're a couple minutes behind. Give us just a minute here.
For the record, these instructions were proposed by...
Thanks for letting us take a little break there.
All instructions that have been given so far will go back. We will start this morning with 2.3 stipulations. I have included the exact language from the written stipulation that you handed to me and that I read in court as part of that instruction.
This could be quick.
Any objection to that? Mr. Levine?
No, Your Honor, thank you.
Ms. Thornhill?
No objection.
All right. That takes us to 2.7, closing argument. That appears to be standard. Is there any objection?
No, sir.
3.1, introduction to final instructions is standard. Is there any objection?
No, sir.
3.2, statement of the charge is standard and accurate. Is there any objection?
No, sir.
Collin seems to be interested in these.
Instructions on the crimes are at the end, but they would come next. And we begin with 7.1, introduction to homicide. That is a standard instruction that states what appear to be the appropriate lessers.
They used to be best friends in that fishing
Yes, Judge, hold on, let me get to it since I didn't reorder that. It does appear to be standard and accurate.
No objection?
No objection.
All right. 7.2, first degree premeditated murder. Appears to be the standard instruction. Is there any objection?
No, sir.
Okay, first degree premeditated.
7.3, first degree felony murder. Appears to be standard. Is there any objection?
No, sir.
These might be lesser included, we're hearing here.
That takes us to 7.4. Well, after that, I would give when there were lesser included crimes or attempts. That is back up. Here, and again, it states second-degree murder and manslaughter as the lessers.
Those are the Category 1 lessers.
Any other lessers requested?
No, sir.
All right, and then for kidnapping, false imprisonment.
Correct. Also a Category 1 lesser.
Any other lessers requested as for kidnapping?
No, sir.
All right.
It was a naughty trial. That was a pretty bad one.
All right, second-degree murder appears to be the standard instruction. Is there any objection?
No, sir. There doesn't appear to be a manslaughter instruction in the packet.
I don't have it either. Let me pull it from the Florida Bar website. Give me just a moment.
I've just got the feel that the jury's going to go with a lesser included on this one. It is anticipated that after this case concludes, Oklahoma may choose to reopen charges against him in the death of his dad. May. The case is open right now, but they may file charges again. Sometimes RA is wrong. I would say often, if not most of the time, I am wrong. Trouble seeing the not guilty here. The crime is just too obvious to me. Yeah. The angle of the knife, the direction, the fact that it would basically, him dragging his mom by the hair would be the exact position that would make that angle of the knife most easy to accomplish. It's like, it's a logical progression if a knife was introduced in that argument. That would be what I would assume would happen.
Right. Crimes or attempts. Is there any objection to the kidnapping instruction as proposed?
No, sir.
All right. So since the state did not include 7.7 manslaughter, is the state asking to proceed on just manslaughter by act, element 2A?
Yes, sir.
Do you agree with that?
I do agree with that.
It will read, to prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. Kathy Griffith is dead. Have you been putting her middle name in?
No, Your Honor.
And then I will take out the A, the letter A. Element 2 will simply read, Collin Griffith intentionally committed an act or acts that caused the death of Kathy Griffith. And then the next paragraph, every person has a duty to act reasonably toward others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously explained to you. In order to convict manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. And that's it. Correct, Mr. Levine?
It is, and thanks for taking care of that, Judge.
Ms. Thornhill, you agree that's all they should be instructed on?
I do agree.
Just a moment.
just getting some stickers sent in the mail to a couple people who'd requested them. So sorry, I'm a little distracted here, but they're flying through these jury instructions. They're going to be done pretty quick at this rate, unless there's some objections later on. All right, Suzanne, Crouch, Corey, John Link, stickers in the mail. Cachette says stickers. Cachette, we have stickers. They are, they're sort of like a, what do you call that? Rainbow reflective base. But it is just our channel logo. It says Recovery Addict on the bottom. It has the pickles, the sandwich, the gavel, the hot chocolate, the stream deck, the TV, and the camera. And if you send a self-addressed stamped envelope, I'll cover the cost of the sticker and send you one.
Appears to be standard instruction. Is there any objection?
No objection.
All right. Maybe back up.
I have 100 stickers left. Well, I have 98 stickers left.
Judge, do you read excusable homicide and
when they're gone,
and
they're
justifiable
gone.
Use of deadly force after the lessers or after introduction to homicide, or?
Well, I generally read that after all lessers, unless you want
Shelby.
else.
Nope.
Shelby and Ryan Applesnapple, happy birthday.
And so that would come next. And let me pull up that instruction. I have it up somewhere, I think, from this morning. Right, that is 3.6F.
If you send a self-addressed stamped envelope, it's basically a blank, empty envelope with a stamp on it and your address written on it.
So we need to talk about that.
Yep.
I put a sticker in. Send it to the post office box. If somebody wants to post the burner box, post office box. If you don't want to do that, there's also, if you'd like more than one sticker, we also have a Sticker Mule store where you can buy 10 stickers with free shipping. I think they ship anywhere in the world, is my understanding. But you can buy a pack of 10. I think they're like $1.70, $1.30. I don't know the price off the top of my head.
The title should just be justified.
If one of the mods can put that link up as well.
Correct.
That's where you can get the stickers. You can order a pack of 10. Those ones aren't free. I can do one free or
self-defense only has to count one, correct?
The first degree murder, yes.
I'd rather be day working. I have a $50 credit on Sticker Mule. I'm going to get a 6-pack of mule sauce.
Constitute the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Collin Griffith does not have the burden of proving that he was justified using deadly force.
This is the self-defense argument here. The instructions regarding
Instead, for you to
self-defense.
find the defendant guilty, the state must prove beyond a reasonable doubt that the defendant was not justified in using deadly force. Collin Griffith was justified in using deadly force. He reasonably believed that such force was necessary to prevent imminent death or great bodily harm to himself, correct?
Correct.
And you are not requesting or the imminent commission of some applicable forcible
No, because the applicable forcible felony would be aggravated battery, which indicates death or great bodily harm, so I think it's unnecessary.
Bless you, Judge.
All right. Is there any dispute about duty to retreat and which instruction I give on that, Mr. Levine? There's either Collin Griffith had no duty to retreat before using deadly force, or one that begins if Collin Griffith was not committing any crime other than the alleged.
Florida's a stand your ground state.
It's a kidnapping.
There's no duty to retreat there. If you're legally allowed to be there.
That's not right.
I don't think he had a duty to retreat. He was in a place that he was allowed to be, in fact, was living there, so it's like it's his home.
I don't disagree that the defendant did not have a duty to retreat. Of course, I said in the context of the defense advancing the self-defense.
I understand. All right, so we'll simply read Collin Griffith had no duty to retreat before using deadly force.
If I recognize some of you are in a very tight financial situation. If a self-addressed stamped envelope is not in your budget, send me a text on the burner phone. I've got 10 or 12 stamps, and I've got envelopes as well.
Second part.
And I'd be happy to send one out if that's the case for you.
So, Ms. Thornhill, that next section is similar to the paragraph which reads, Collin Griffith was justified in using deadly force if he reasonably believed that such force was necessary to prevent imminent death or great bodily harm to himself or others. But then this next section encompasses the same context, but or the same law, but in the context of stand your ground. I don't think both need to be given, but is this what you're requesting, or just the simple to prevent?
I mean, I would rather have both, just in case the jury thinks that he didn't have a right to stand his ground in this house that he had a right to be in. I realize it's somewhat duplicative, but it's the standard, and that's what is allowed for. It doesn't say give this or this.
Catch that. Thank you very much.
Mr. Levine?
No objection.
All right, so
Natalie, thank you.
Next part we'll read. Collin Griffith was in a dwelling or residence.
Residence is fine.
Was in a residence in which he had a right to be.
No police interviews were
He had no
shown.
duty to retreat and had the right to stand his ground and use force, including deadly force, if he reasonably believed that such conduct was necessary to prevent imminent death or great bodily harm to himself.
That's correct, and B is not requested.
It's crazy that just on Friday Thursday and Friday we were arguing in this court about whether
Section is not applicable, correct?
the jury would get to hear a text message you shared with his lawyer
The use of deadly force is justifiable.
about stabbing his mom in the neck.
Defendant reasonably would believe the force was necessary. I'm sorry. Yes, to prevent great bodily harm to himself while resisting any attempt to murder him, commit a forcible felony, or commit a felony upon him, or commit a felony upon or in any dwelling in which he was present. Are you asking for any of that?
Well, and once again, Judge, it seems duplicative, but since it's not in the disjunctive, and it's entirely possible the jury could believe that Kathy was trying to murder Collin or at least commit an aggravated battery upon him, I would request it.
Mr. Levine?
No objection.
I think it's a win just to get those jury instructions in.
Yeah.
Because that's something the jury will hear and be thinking about.
The force is justifiable if Collin Griffith reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself while resisting any attempt.
Ooh. Evangeline, I'll look for that. Writing addresses here real quick.
Or commit an aggravated battery upon him.
Yeah. Can we also add aggravated assault?
I don't object to the aggravated battery. What was the context, Your Honor, again, of the aggravated assault request by the defense?
They wanted to read, the use of deadly force is justifiable if Collin Griffith reasonably believed that the force was necessary to prevent imminent death or great bodily harm to himself while resisting any attempt to murder him or commit an aggravated battery or aggravated assault upon him.
No objection.
DSN, thank you very much. Someone posted the P.O. box again. There are a couple of people that still need it. I'll put it back on the screen. Thank you, Sharon.
But the last paragraph you're not asking for.
No, C?
Yes.
Correct. I'm not asking for that.
Right. This next part about law enforcement and excessive force is not applicable. You agree?
I agree.
Now, in deciding whether Collin Griffith was justified in the use of deadly force, you must consider the circumstances at the time force was used. The danger need not have been actual, however, to justify the use of deadly force. The appearance of imminent danger must have been so real that the defendant actually believed the use of deadly force was necessary, moreover, to justify the use of deadly force. A reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force, was necessary. Right, this next portion about presumption of fear is not applicable, correct?
I don't think it's applicable, Judge.
Okay, they're just going through each one of these instructions to make sure they get everything read properly to the jury. Should be done here fairly quickly.
Paragraphs, correct?
I agree.
The lawyers are reasonable. They seem to be able to work together fairly well.
Nothing about a presumption of intent to commit an unlawful act. Agreed.
I agree that that is not applicable.
I do need to define residence, correct? But not dwelling, since we haven't chosen that.
Right, I think
Do you
residence
agree,
is-
Mr. Williams?
No objection.
I do not need to define vehicle, correct?
Correct.
All right. And then there's this part. However, the use of deadly force is not justified if you find that Collin Griffith was attempting to committing or escaping after the commission of an applicable forcible felony. Am I getting that?
I am not.
Yes, sir.
Okay.
Or kidnapping, correct?
Yes, sir.
Is there an objection?
No.
All right.
There's been almost no argument about these. Everyone's getting what they want. Everybody should be happy with these instructions. Say it sounds like a win already for the defense. Just the reading the instructions about self-defense, the instructions about that he has a reasonable, no duty to retreat, everything else. That's like one more good argument
is not justified
on their side right before the jury decides.
I don't think that.
Good. I don't know that that applies, does it, Mr. Williams?
No objection.
All right, so that whole section comes out. All right. And then I'm assuming you want prior threats or difficulties.
Yes, please.
So that will be if you find that Collin Griffith, who, because of prior threats or difficulties with Kathy Griffith,
I know Collin had a bit of a trust for his dad's death. He had some money coming to him from that.
in danger of death or great bodily harm at the hands of Kathy Griffith. You may consider this fact in determining whether the actions of Collin Griffith were those of a reasonable person. If you find that at the time of the alleged first degree alleged first degree murder, should it also say the lessers?
As with the previous section in the same instruction, it could say first degree murder and all included lessers.
If you find that at the time of the alleged first degree murder or any lesser included offense, Collin Griffith,
Judge bailiff and back, big yawn.
knew that Kathy Griffith.
And Judge, I'm sorry to interrupt. The state's proposed instructions uses Catherine Griffith, so we should probably be consistent throughout.
All
I'm
right,
sorry.
I'll make that
Yep.
change
Got it.
before I finalize them. Thank you for that. All right. Catherine Griffith had committed an act or acts of violence. You may consider that fact in determining whether Collin Griffith reasonably believed it was necessary for him to use deadly force
Jury instructions seem pretty clear. There's a lot of different options for them to consider.
As to these two reputations, are you asking for one or both?
Both, please.
Mr. Levine?
No objection.
All right.
Mr. Levine is giving everything away.
Catherine Griffith had a reputation of being a violent and dangerous person, and that her reputation was known to Collin Griffith. Wow. You may consider this fact in determining whether the actions of Collin Griffith were those of a reasonable person in dealing with an individual of that reputation. If you find that Catherine Griffith had a reputation of being a violent and dangerous person, you may consider this fact in determining whether she was the initial aggressor. Then, in considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Collin Griffith and Catherine Griffith. And that is it, correct?
Yes.
Any other comments, requests, suggestions with respect to justifiable use of deadly force?
No, sir.
That's awesome, Drumalama. I'll watch for
All
it.
right.
And one quick question, is it my understanding that all the proposed subsections of justifying the use of deadly force have come from the standard jury instruction? There's no special request by the defense?
No special requests.
Everything, what was sent to me by Mr. Thornhill appeared to be directly copied from the Florida Bar website. So.
Yes, it was.
Willie, welcome. Thanks for clicking the subscribe button.
We can back up.
So, Florida law lets you consider if the victim had a reputation for violence.
Follow that.
I read, are you talking about introduction of homicide?
No,
Determine if she was the
there was
aggressor.
actually an excusable homicide instruction that was provided in the packet that the state.
Where is that?
I don't remember where it is.
The introduction to homicide portion, I'd have to scroll down to confirm, but
I didn't see that in the copy. I mean,
You're right.
excusable homicide is included in introduction to homicide.
But it doesn't give the explanation of what the circumstances are under which it would be excusable.
It was an incomplete instruction.
I would say these
I
instructions.
have, the killing of a human being is excusable and therefore lawful under any one of the following three circumstances: when the killing is committed by accident or misfortune, when doing any lawful act by lawful means with usual ordinary caution without any unlawful intent, or two, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or three, same thing, if a dangerous weapon is not used and the killing is not done in a cruel and unusual manner. Is that what you were referring
Yeah, that's
to?
what I'm requesting, and maybe it just is part
think what
of
it is-
introduction to homicide. It just.
I think what it was is, because the standard instruction has the two sections, justifiable and excusable, and they're all caps in the standard instruction, and probably what happened is
The second page.
went to a second page.
Thank you, Zena.
Got it.
That's in there. All right. All right, after self-defense, are there any aggravator instructions that need to be given for weapons or anything like that? I didn't see any.
Your Honor, I think in the verdict form, there's special findings, and you're right, there should be an aggravator as it pertains to the knife and the weapon, but I don't believe that I remember to include that.
I think these instructions are very beneficial for the defense. I think that what they got included is
aggravation by carrying, displaying, using, threatening to use, attempting to use a weapon. And was that charged in the indictment?
Yes, sir.
Yes. Sure.
Just to count one, I believe.
Yes.
Sorry, there's somebody going back and forth around my house revving their engine.
So that is 3.3A.
I'm sorry?
That's 3.3A. Do you object to that instruction being given?
No.
All right, let's hammer that one out real quick.
Collin's had a couple moments during this trial where his face seems to indicate that he's somewhat pleased with either what he's seen or what's happened.
All right, so that will read it will be aggravation of, now, Mr. Levine had this discussion with, he's a juvenile, so I think it is appropriate in this case. So it will be aggravation of first-degree murder, second-degree murder, and it does apply to manslaughter,
Yes,
correct?
sir.
Because it's a level enhancement, correct, not amendment.
Correct.
So it does not apply to first-degree murder. I don't think that prosecutors take a different, I mean, there's,
As it
it's a
pertains,
capital crime, so I mean, you can't.
Right,
really
you can't
the
enhance
level.
it.
and on my verdict form, if I remember correctly, I don't have a special finding as it pertains to first-degree murder.
So it should read aggravation of second-degree murder and or manslaughter, correct?
That's acceptable.
You agree, Ms. Thornhill?
Yes.
Only 60 objections.
By carrying, displaying, using, threatening to use, or attempting to use a weapon. And then it will read, if you find that Collin Griffith committed second-degree murder or manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a weapon, you should find him guilty of first-degree murder with a weapon or second-degree murder with a, second-degree murder with a weapon or manslaughter with a weapon. Agreed?
Yes.
Yes.
I don't need to define firearm.
That is correct.
And then I'll define weapon. A weapon is defined as any object readily capable of inflicting bodily harm if used in the ordinary manner contemplated by its design and construction, or to any other object. Do I need to do any other object?
No, I think it's,
Pretty clear.
yeah, we're
Do you
dealing
agree,
with a knife.
Mr. Levine?
I agree.
All right.
Check and see how close we are.
So I'll take out the one as well, so it will just be one sentence. Then the final paragraph, if you find that Collin Griffith committed second-degree murder or manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a weapon, then you should find him guilty only of second-degree murder or manslaughter. Correct?
Yes.
Yes.
All right. There is no instruction on the issue related to juveniles. It's just a verdict form issue, correct, with the findings of actually killed, intended to kill, or attempted to kill, correct?
Yes, I agree.
All right, so that will take us then to 3.7, plea of not guilty, reasonable doubt, proof. This is the new standard instruction, I believe, correct?
That I don't know.
Well, it may not be, and I thought, because I've been giving this instruction by memory now for probably 15 years, but I never noticed until recently that first sentence of what a reasonable doubt is not. I never remembered it saying proof beyond a reasonable doubt does not mean proof beyond all doubt. I thought it just started with
a reasonable
doubt is not a mere possible doubt. So I think this is new. Any objection?
No.
All right.
Proof beyond a reasonable doubt is not proof beyond all doubt.
And I am assuming, Mr. Levine, that is pulled from the most current version on the website.
That was my intent, Your Honor.
All right, let me look just to be doubly sure.
Mr. Levine should have just said yes. I've heard it read that way before. I think even in Florida.
In my office, I wouldn't say it was necessarily pulled from the website, but pulled from our computer that is supposed to be the most up-to-date jury instructions originating from the website.
And it's in there. It's on the website.
That's favorable to prosecution.
New standard language. Oh, yes, it was amended May 2024. All right. Any objection to reasonable doubt?
No.
3.9, weighing the evidence. As to this appears to be standard. As to the factors for consideration, 1 through 5 are always given. Do we need money or preferred treatment?
I don't believe so, Judge.
Mr. Levine?
I agree.
Pressure or threat?
I don't believe that's applicable here.
Mr. Levine?
I agree.
I will give inconsistent statements. Is that agreed?
Sure.
Mr. Levine, you agree?
Oh, yes, sir.
There's no felony or misdemeanor conviction, correct?
Correct.
And no reputation for truthfulness, correct?
Correct.
Do you agree, Mr. Levine?
I agree.
All right, so I'll renumber inconsistent statements as number 6. All right. The rest is standard, including expert witnesses. I will remove the defendant becoming a witness.
Yes, please.
And the rest appears appropriate. Agreed?
You have
Yes.
Yes.
defendant's choice not to testify in there?
Do you want me to give 3.9A defendant not testifying?
Yes, please.
Yes. That one.
And am I giving 3.9B defendant statements?
Yes, please.
All right. Rules for deliberation appears to be standard. Is there any objection?
No objection.
Cautionary instruction is standard. Any objection?
No objection.
3.12 verdict.
I would object if I thought it would do any good to, you don't have to be unanimous on the premeditation or the felony murder. But I don't think I have.
You're making a record preservation objection?
Yes, I am making a record for preservation purposes.
Do you wish to make any argument?
Just that I think that the unanimity requirement should apply to the different theories that the state has put forth as to first-degree murder. I think that the instruction should be your verdict must be unanimous either as to premeditation or unanimous as to felony murder.
Any response, Mr. Levine?
No, Your Honor, I would ask that you instruct the jury on the standard jury instruction.
Law, as I understand, has not changed, and that under Florida law, they do not have to be unanimous as to the type of first-degree murder, only that it be one or the other.
So each juror can have a different reason for voting for first-degree murder, as long as it
This should
qualifies.
go before the paragraph above it.
Yes, it should.
Do you agree, Mr. Williams, that the last paragraph should go above the second to last paragraph?
They don't have to be unanimous about
Whoever's supposed
how
to
the
vote.
murder was committed that would qualify as first-degree murder.
All right, so that's where I'm going to put it, and you agree with that?
That's fine.
We'll talk about the verdict form in just a second. Single defendant, multiple counts, I'm taking out for information in the title. But that appears to be standard and includes the caveat for legally interlocking counts. Any objection?
No objection.
That takes us to legally interlocking counts. Now, if I remember correctly, the last paragraph is not standard, but it's something that has been used before, so this is sort of a special instruction, correct, Mr. Williams?
If I remember correctly, yes. I believe in these cases, maybe even Your Honor proposed it or gave the parties an option, and it seemed to make good sense and describe everything clearly and accurately. If the defense has any objection to something, I don't object to if they want something taken out that's beyond the standard.
So Ms. Thornhill, the first two paragraphs appear to be standard and accurate. That last paragraph reads, however, the alternative crime of first-degree premeditated murder charged in count one is not linked to any other count in the indictment. A finding of guilty or not guilty as to count two must not affect your verdict as to the first-degree premeditated murder charged in count one.
I think that's an accurate statement of the law. I don't have an objection to it being read, even though it's not part of the standard instruction. It might actually help them figure things out, that they actually notice that one is felony murder and one is premeditated murder.
So as to the rest of that instruction, any objections?
No.
All right. And that takes us to 3.13, submitting case to jury, which is standard. Is there any objection?
No objection.
Now the jury form,
instructional
verdict form.
No objection.
All right. Are there any other, before we talk about the verdict form, any other standard or special instructions requested by the state?
No, Your Honor.
By the defense?
I'm sorry, hold on.
Whisper, 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 whisper. The defense has gotten virtually everything they want in these jury instructions. A lot of times, this is one of the most heated sections of the trial because the way things are presented to the jury can definitely sway.
Any other standard or special instructions requested?
No.
All right. Let's take a look at the verdict form. Here is the verdict.
Verdict form. These are going to have all the lesser includeds.
So as to count one, the first choice is for first-degree murder as charged in the indictment. Second choice, the defendant is guilty of second-degree murder, a lesser included offense. And under that, the further findings, and then manslaughter, which does not have the further findings. So my thought is we separate the verdict form into guilt findings and then special findings separately, since it would become repetitive if after second-degree murder and manslaughter they're the same section of special findings. Does that sound fair, Mr. Levine?
It does, Your Honor, and I would ask that you add the language under manslaughter that's there for second-degree murder, the special findings. It was I didn't put it on there as an oversight.
I think also the finding as to actually killing, well, you've only proposed that they be asked about actually killing Catherine Griffith. You don't really need any of the attempted to kill or intended to kill language.
Yeah, by operation of the facts of this case, I'm okay with it just saying actually killed.
That's fine.
All right.
But I
Go ahead.
because he is a juvenile, and that's what those special findings pertain to, would you put it under after the guilt findings, then do that as a further finding? That's what you were indicating. Okay.
So we would basically have count one and count two. It would be count one in order: first-degree murder, second-degree murder, manslaughter, not guilty. And then count two, kidnapping, false imprisonment, not guilty. Then special finding question one: if you found the defendant guilty of first-degree murder or second-degree murder, you must answer the following question. The defendant actually killed Kathy Griffith? Yes, no. And I explained when I'm going over the verdict form that those also have to be beyond a reasonable doubt and unanimous findings.
You can find him guilty of first-degree murder without
So that's special finding one. Special finding two: if you found the defendant guilty of second-degree murder or manslaughter, you must answer the following question. The defendant carried, displayed, etc. Yes or no?
That makes a lot of sense.
Mr. Levine?
Yes, sir.
All right. So I'm not going to pound through that here while you're sitting in front of me. I'll just correct it.
Thank you.
And email everything to you all this afternoon so you have it. And if you see any errors, today, it's invariably, as I'm reading the instructions, I see one, but I would ask that you review them, and if you see any typos or other errors, to just alert me by email so they can be changed before they're printed tomorrow morning.
Yes, sir.
Is there anything else we need to take up this afternoon?
I don't believe so.
All right. And I told the jury they'd probably be going to deliberate around lunch. Are you anticipating all-day arguments?
No, Your Honor, I think they will be deliberating by lunch.
I agree.
All right.
Okay, about an hour and a half each.
All right. Everybody enjoy the rest of your day. I'll see you at 8:30.
Thank you.
All right.
All right. So with that, they are done in the courtroom. We're done with them. We'll be back tomorrow. So where it is right now, the jury's gone home. They have sorted out all the jury instructions in that conference. So everything the judge is going to read to the jury has been decided on. He's just going to polish it up, send it to them for approval. The verdict forms are set. The jury will hear closing arguments after the judge reads them all those jury instructions tomorrow morning. We'll probably have, by the sounds of it, it'll probably be about half an hour of jury instructions and then an hour to an hour and 15 minutes maybe each of closing arguments for the state and defense, and then the jury will be deliberating by lunchtime. So very likely that we do get the verdict tomorrow in that case. I will say 4 hours is probably enough in that case, but we'll see. So tomorrow's closings. Yes, tomorrow's closings. This case ended rapidly. There was one witness for defense. It was grandma. testified for defense, and everything Grandma said was, my daughter was the aggressor, my daughter caused the problem, she was the one that attacked him. Collin's great, Collin's wonderful, Collin's amazing, daughter was the problem. Wow. There was a lot of that. I will say I'm impressed and amazed, and I was wrong. Nobody slipped up throughout the whole trial, and they can still do it in closings, but nobody let loose that it was actually Collin's dad was the person that he shot and killed in Oklahoma. That did not come out. That was good, because that would have been a mistrial. So barring that slip up in closings, I think we're good there and safe. But Thursday we had a long, spicy argument that was decided Friday morning because Collin had been texting on his phone that his mom sees. His lawyer, yes, he had a lawyer in the case, the domestic assault case against his mom. Well, actually, his assault of his mom. I think Collin was the aggressor there. His mom was the victim in that case. She's still in custody. They're together. He's texting his lawyer, and in those texts, he proposes that he might do something, and it could be in response, in self-defense, or it could have been I just have this idea. Here's what I want to do. But he used the words the old knife to the old knife to the neck routine in those texts. And the state tried to get that brought into the jury. They tried to pierce the attorney-client privilege because of the third party present being the mom in the conversation. She has the right to. The mom actually shared the message with Susan, who was the grandma, and they tried to bring it in that way, and the judge kept it out. So the jury did not hear that evidence. The jury's had the most spicy stuff in all this case the jury has not heard. The little tidbits at the very end as we chase a rabbit down a path and get to the end result, the jury has not heard those. The judge has been very careful, making sure there's not information brought into them that is too prejudicial beyond being what's needed for being probative. So interesting. I think we are, Selena. I will say it's going to be a hard case. It's going to be a hard case because there's a child victim. But we've had a lot of interest in the Boswell trial. They're in jury selection right now. I don't know if they're going to be able to seat it today or tomorrow when that's going to happen. But Kitty, welcome to the gallery. Love that green courthouse. Thank you very much for your continued support. I think this is a travesty of justice, and he will unalive again. Well, Barb, if that were to, first of all, if it is a travesty of justice, and a guilty man goes free and he does kill again, that will be a very introspective moment for a lot of people, I think. But we'll see. Oklahoma's still got that open case against him, the open investigation. I would like to have heard from the older brother. Yeah, crickets from them. Crickets. If released, he'd probably go live with his grandma, or he's nearly an adult. So... Tracy Barlow, thank you very much for the kind words. Yeah, Kathy, pretty much everything that was shared about Kathy was not good, both if it was on videotape, on audio recording. The fact of the matter is I don't think she was, going for the Parent of the Year award by any means. Selena, thank you. Appreciate that. We're gonna do our best and try on that one. Got a call coming in. Let me see if I can grab it before it hangs up.
Call from Regina Crawford.
Regina, this is RA. How are you doing?
I'm good. How are you?
Fabulous. What's happening today?
I wanted to call in to tell you about my jury duty experience.
Oh, are you all done? First of all,
I'm done.
Okay.
Yes, it was Friday, and it was. Yes, I wasn't going to call in before I was done.
I trust you, but I just wanted to be sure.
Yes, it was last Friday, and it was an intent to deliver. He had 17 bags. Yes, 17 bags of crack cocaine.
17. That's a lot.
It was I think they said 4.9 grams. but he had them all in separate bags. So he had like 8 of them in these little, they call trash cans, which I learned. They're very tiny little small containers. And then he had 8 more in the other ones.
So he divided it up into basically single dose usage.
Yes. And he said he was just a drug user.
And he
But
just
get
likes
this,
to keep a supply.
Well, he had no drug paraphernalia. Like he didn't have any pipes or any anything to use it with. So, and it was he was stopped, like parked in the middle of the road when the cop pulled him over. And he said it was his, so the possession wasn't a problem. It was just getting him to the intent to deliver. And it ended in a mistrial.
Whoa. Now, obviously, I can't ask you to divulge what happened in the deliberation room. Did it get heated though? I mean, was it?
Yes, it did. It did. It's hard. Like, think about a trial that the people are there for 6 weeks. They kind of get to know each other. We were there one day.
Was there any bonding? Was it all like, we're in this together type thing?
Some people were, but most people were like, they went around and did like a vote first. And so like, it was 3 and 9. And then we talked again and we couldn't come to a decision like an hour and a half later. So then we told the judge, she brought us out just like on TV. And then, she told us to go back in and give it the old college try. And we tried again and we still couldn't get the one person.
So two did,
2 turned.
acquiesce, 2 turned.
Yeah.
Was everyone's argument, was their reasoning valid, or was just like I just think he shouldn't? Was there anyone who just seemed to be, make a decision on a coin toss?
The one that went with not guilty said he couldn't see, like, it could be a user based off of his experience.
Okay.
Which
when you said 17 bags, I was expecting 4 pounds. I mean, I was expecting a lot, and 4 grams is not a ton.
It's not, but like in the area, it's probably for the people who just want a $20 bag or a $30 bag. Yeah. Who's going to buy 17 bags and go home and do it yourself? Like, it just didn't make sense to me.
One for you.
It just didn't make sense.
That's a party in the making, but not a good one.
Yeah.
Did you learn more about drugs than you ever wanted to know?
Yes. Especially the little trash cans. I'm like, a what? Trash can? And the prosecutor was funny. He comes out and his first thing he says is, if it walks like a duck and it acts like a duck, it's a duck. This duck is a drug dealer.
That's a good one-liner. Tell me a little bit about jury selection. How did you get through the voir dire?
So that was Monday, last Monday. And it was 149 people for 2 cases.
All right.
And I didn't get picked for the first round. I think that was a trespassing case, they told us. The second round, I think they picked 34 people to go in. So you go in, it's kind of cool. They walk you in like by number and have you sit down. And then the same, like we had to answer a jury questionnaire that they sent out to us. Do you know police officers? Do you know attorneys? Have you ever been convicted of a crime? It was like 12 questions. Yeah. They asked you those same questions. And then if you said yes to them, you had to stand up and then the judge would ask you, are any of these
follow-ups?
Yeah, like, is this going to change is this going to affect your verdict or what you think? Yeah. And then it's almost like they went down the line and picked like every other person in a row to go. Because it wasn't, I guess, a high-profile murder case. I mean, I think if it was homicide case or something, it would probably take longer and they would probably ask you more questions.
Yeah.
Yeah.
That's fascinating. Did you answer any? I mean, I don't want to know what the questions were, but did they ask you specifically any questions that you had to answer?
Yeah, just because I knew retired police officers.
Oh, okay.
And they asked me, the same thing, because my father-in-law is a retired Pennsylvania state trooper, and a friend of my husband's is a retired. Yeah, so it was, at first I didn't want to go. I'm like, I don't want to go here. I don't want to do this. I have so much work to do. I'm going to miss everything I see on YouTube. Well, RA, everybody, what am I going to do? And I really enjoyed it.
So tell me this. Tell me this. What are you going to spend all that jury pay money on?
I don't know. It's $9 a day. Guess I could buy myself some lunch.
Did they give you lunch, or were you done before lunch?
No, they did not give us lunch. They said if we had to stay through the evening, like if we couldn't come to work, they would feed us supper. So they gave us an hour and a half lunch, and then brought us back and did the charges, and then we went into the deliberation room.
That is fascinating. Regina, what would you tell somebody who just opened up their mailbox today and for the first time has a summons to appear for jury duty? What would your advice
Go,
be?
because go, because it's so important. Like, it really is. And, you're not, I guess that, like I said, I didn't want to go, but once I went, you learn so much about the process. And, I mean, it's not a perfect system, but it's a system that works. You know.
Awesome. And now you're excited for your next letter.
Yeah, I can't get picked for a year.
Oh, bummer. You have to move.
Yeah.
You move that resets.
I have to move to a different county. Yes, to move to a different county.
Regina, I am so excited, first of all, that you got to serve and you got that experience. You may not have gotten the outcome that you thought was appropriate, but wow, I've never, ever even been summoned.
I know.
I'm jealous.
I know. My mom is going to be 80, and she's been wanting to be called for jury duty like her whole life. And she was like, "I can't believe you got called. I've never been called."
My mom is not a U.S. citizen, and she's been summoned like 3 times, and I don't know how.
Really?
That works.
How do they do that?
I don't know.
Well, here it's based off your voter registration and your vehicle. I guess it's everywhere like that, and your vehicle registration.
Yeah.
So I don't know.
I've tried. And now I'm pretty sure no one will take me. Regina, thanks for calling and thanks for sharing that. I'm glad you got an experience that wasn't traumatic and was.
No, I just wanted to share with everybody.
That is awesome. Regina, thank you very much. Have a great day.
You're welcome. You too.
Bye. Let's see. Once you say what you do every day, they probably won't let you on. Yeah, I'm pretty sure. It's like, well, I follow court cases online and commentate. And Lynn, I get summoned every year. Where do you have to live to get to serve? That's crazy. Norway, Cookie. All right. This chat is a way better family than I have. Not as bad as the defendants, but I really don't claim my family. Laura, that's sad, and at the same time, I'm so happy to have you as family here. Thank you. Welcome to our little family. A big virtual hugs all around for everybody. Britt P., I was on grand jury for 6 months. Oh my goodness. I don't know. I think I might be able to sit on a grand jury. I think they'd let me. It's the small ones that I think they'd throw me out. Because grand jury is different, right? Grand jury, you don't have defense there asking questions. They happen without defense even knowing about it. Haven't been summoned in 10 to 15 years, but my husband has been called 2 times in the last year. Missed this morning. Did the text? Yes, Laurie, it did. It did get squashed. And some of the impeachment of Grandma got squashed. The defense won some, what I would describe as key objections. They lost the vast majority, but they won very key objections. And I think throughout the judge seemed to be concerned that that the prior information about Collin and about what happened before was so prejudicial that he kept so much out to make sure there wouldn't be a reason for appeal there. And I think he did pretty well at that, maybe even too well. Does knowing the little man in the corner exclude you from jury duty? I don't think so. You can't play that card. Are waiting on something? I thought the jury comes back tomorrow. It does come back tomorrow. We were just talking a little bit. I know we have we've got a couple things that happened today. It's 1:00 where I am right now. I've got a couple hours before my interview with Courtroom Confidential with Josh. I'm super excited about that. We have to reshoot it because there was a technical issue, but I'll be doing that tonight, this afternoon. And then we also I'll be on with Courtroom Confidential Wednesday night on their channel, 8 to 8:30 p.m. I think that's Eastern time. So excited to spend a little time over there with Josh. Their channel's amazing. It's amazing. I don't know why it doesn't have 700,000 subscribers yet. Let's see. We do have another case coming up in Thurston, Washington. We've got a case that's in jury selection right now that we're going to jump to as soon as this one is done. So plenty of court to watch. We just might have an early afternoon this afternoon. You mentioned only $9 today. Here we get $50. Barb, $50 a day. Man, for that price, let's stretch out deliberations a little bit. That's the most I've ever heard a juror get paid a day. And you probably get free food too. Get summoned every 2 years. I'm jealous. I'm jealous of all of you. Let's see. Oh, look who it is.
Call from Angela.
Angela, how are you doing?
I'm doing good. How are you?
I'm doing just great.
I missed you on Friday, but I caught up on live streams yesterday with the rewatch crew.
Thank you. Hopefully the ads weren't too unbearable.
I learned how to bear through them. Yeah. First, congratulations on being on the Courtroom Confidential. I have followed Josh since way before he started on Courtroom Confidential. He is, I think they changed the name of the channel, but he is one of the hosts on the True Crime News, something like that.
Yeah.
He started over there.
He's got such a good sound. He's got a face made for TV, a voice for radio. He's very professional. He's a fun guy to hang out with and talk to. It's just awesome. I'm really excited about it. And he's got all sorts of experience.
Did you know he worked with Alan Jackson?
No, I didn't know that. He didn't tell me. I'll have
he
to
worked
bug him
with
about
Alan
it today.
Jackson.
That is awesome.
Yeah.
That's cool.
So, and he also know the guys that represented Weinstein in New York.
Ooh.
He had him as a guest on that other channel, the True Crime News. Whatever they changed the name recently. I don't remember the new name of the channel. So yeah.
That's awesome.
And also, yeah. So yeah. That I just wanted to tell you something. There is apparently a website that you can be a mock juror for where law firms can go and test their cases and strategies. I need to dig up that link, but you can sign up, and if any law firm in your area is looking for a mock juror, you can be picked.
They probably pay worse than a regular jury. It's probably volunteer only.
Well, I don't know what the pay rate is. But I do know it exists.
Wow.
I want to sign up, but apparently it's only U.S.
Only U.S. I don't know. I don't know if I could do a mock jury. I want the real thing. Because if I knew that it was like, this is all just pretend, at the end of the day, the jurors are just going to crunch the numbers and then do their own thing anyway. I don't know. Hang on. I need to show this.
Lewistown.
I've got, this guy's got like all the colors. I just jumped to Thurston, Washington court. There's a guy with like a fancy, like my desk with all the lights. He's got that behind him as his backdrop. Now he's gone. they shut it off. All right. Sorry. That just caught my eye.
Yeah. Yeah, it's all right. Nothing. I just wanted to say that, and I'm going to look forward to watch your interview with Josh on his channel. So yeah.
Awesome. That's great. Thank you very much. I appreciate it, Angela. Thanks for making the call as well. It's good to hear from you again.
Thank you. You're welcome. Bye.
Helena Handbasket says, I tried to tell you Josh used to work with Alan Jackson like 3 times after you announced your interview with Josh, and I missed it over and over. I'm sorry. We're sort of early, but I also wanted to do a little court hopping just to round things off. Let's see what's up here. We've got. This is Thurston.
Really
Candy.
muddled. I can't hear you very well. I don't know about your.
Sounds like you're underwater. Oh, the guy's back. Jay Garhart. Sounds like your computer is underwater.
Is that better?
Yes.
That's much better. All right. Who's your client?
Jordan Garhart. He's present on Zoom. He's on the 10 a.m.
All right, Mr. Garhart.
Can you turn off your lights and
Why don't
turn
you
on your
unmute,
camera?
start your camera. There he is. Mr. Carr. Okay, so it looks like there's been a conviction entered on one case. Trying to review my notes here. Cowlitz County Superior Court, maybe? Yep.
Yes, Your Honor.
Last week.
That's correct.
Sentencing's coming up this next week on that one. So, Mr. Weston, where are you on the matter here?
And Your Honor, if I just may,
Sure.
the defense stipulate to the violation and ask this to be set for a sanction hearing after the February 13th date. My understanding, Mr. Garhart is likely to be getting a mental health sentencing alternative, and I just want to make sure that we have enough time to negotiate a proper sanction that won't be getting in the way of his sentence in Cowlitz.
Mr. Weston, any objection to that?
Mr. Weston and Mr. Pazdarka have the same beard. They share it.
No, Your Honor.
Well, Mr. Garhart, I find you're in noncompliance, but, and so we're going to give you a chance to get past that sentencing and come back, and I'll give you a court date today, and we will see what occurs then.
I just wanted to see this guy's window. I'm going to cut away from this right now. Real quick. He's going to get a court date. There are a couple things going on in Thurston. I'm not sure if the case we're looking for has started yet. Let's see. We've got another magistrate.
What time were you given for your court date today?
Out here, but they wouldn't know. You know,
Yeah, the door's not been open. Okay.
open to review my last time.
All right, thank you. And then, sir, in the back, are you here for court too? Are you here for court today too?
Yeah.
And what's your name?
You have to,
How do you spell your last name?
Explain.
Yes.
you have to unlock the door if people have court. All right. Not seeing any of the cases up there that we're looking for. Although all our favorite magistrates and judges are on the bench right now up there in Thurston.
Yes, it says service one was given
Okay, so nothing happening. All right, so here's what we're going to do. We are going to watch the jury selection. Well, we're not going to watch, but in the Boswell trial, we're going to keep an eye on the jury selection for when that's going to begin. We have closing arguments tomorrow in the Collin Griffith trial, and probably a verdict. But if the jury gets seated and they begin tomorrow, during verdict watch, we're going to pick up the opening statements of the next trial. So we'll have no breaks. Other than that, we're going to take a lunch break now, and that'll pretty much take me to just right before I prep for my interview with, get my hair done, my nails did, and all that. Just kidding. I'm not going to do that. I might comb my hair again before my interview with Josh, but that's it. So we do have an early day today. Is there anything else you guys wanted to bring up or talk about before we split for the day and come back again tomorrow morning with continuing with the closings? So many trials. There's so many trials. There are a lot. We can't pick up all of them. That's the only problem. Attorney Swanson is an Olympia attorney. Yep. Love Thurston. Front door. Put deodorant on. Thank you, Kelly. Good advice. Deodorant. 6-fold. You're funny. Yeah. Thank you. I'm glad y'all could be here today. It's been a lot of fun. Even though we had quite a group, it's been y'all have been good. You've been nice and going nice on the mods, not making their day miserable. I don't know when the interview is going to air on Courtroom Confidential now. Obviously, their editor needs time to put it together, and I think I have to supply like pictures and stuff that they request. So it's going to depend on that too. Hang on, we've got a call here.
Call from
Master Ayden.
Master Ayden, the music started, so you got to talk quick. What's happening, my friend?
Okay, I hope to have a guilty verdict tomorrow. Have a good day, and I hope you do great on your interview.
Thank you very much. Appreciate it.
All right.
We'll see you.
Okay,
bye. Lois says, wait! Lois, I'm here. I'm waiting. How come we're covering a kid trial? This particular trial has a ton of interest in it. Mostly because of the Amber Alert and the 2-week thing that went out. We don't cover a lot of these. I think the last one was probably Letitia Stout. Yeah, lots. We're going to try to cover it as carefully as possible, and sometimes they're important to cover. That's all. All right, let's see. I didn't see Lois come back with an answer. I think she was just saying wait because there was a phone call. Thank you, everyone. Appreciate it. We've had a ton of new members today join us. Welcome. Please join us again tomorrow. That was it. Just wait for the phone call. Okay. I was waiting for you to say something, see if there's something else. Tonight, when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe till we go live again tomorrow morning at bright and early, 8:30 in the morning, I think is going to be the start time. We'll see you. You guys have an absolutely fabulous day. Bye-bye.
Because he's the guy. Thank you, sir. You're my new best friend.